Any mention? Any mention?
Very good.
Your Lordship, I beg to mention item number 56, if this matter may be taken up after 2 weeks.
50?
56, Your Lordship.
Two weeks, yes. After pujas.
Your Lordship. Mashallah.
Please, Lordship, I beg to mention item 47.
47.
Yes, reconducting senior counsel
Other
is
side.
on sanction leave.
And I said you informed.
Yes.
How's Mr. Chakravarti? He's recovered. I believe he had a health situation.
Yeah. Yesterday only.
Lordship, I beg to mention item number 36.
Yes.
Highly obliged.
Pujas, yes. 36.
I beg to mention item number 36.
Yes.
Yes.
36. 36 orders. You don't mention order matters. They have to be called out. Yes.
Lordship, I beg to mention item number 50.
50.
50. 150.
50, yes.
Oh, sorry, Lordship. 57. 57, Lordship.
Yes.
Lordship, I would like to make small prayer, my lord. If your Lordship permits to allow us to file additional affidavit, bring on record some documents.
We have to hear the other side. Why? What actually for what? What additional affidavit do you need?
Some documents, my lord. We want to bring on record some documents.
Is court ready to hear the matter today?
Yes.
What documents you will bring on record?
Like the post-mortem and the deposition of
Is it necessary?
certain.
Because the only thing is that your only prayer here is that for sending the this investigation, which FIR file to CBI, correct?
Yes.
That's the thing. Anyway, who's up here on the other side? No, you have no objection.
Your Lordship, my senior AG
Who?
is online.
Who's there? Yutika Pallavi?
No,
Oh, yes. Oh, Miss, yes. No objection.
Now, Your Lordship may have it. No objection, Your Lord. Let them file what they want to file.
Okay, Mr.
But the issue is very short. Issue is very short.
Yes.
My Lord,
Mr.
right,
Alphas, Leonard, counsel for the petitioner, submits that certain documents are necessary to be brought before the court for proper adjudication of the matter. He prays that he may be allowed to file additional affidavit. Next paragraph seems objected to by the Learned Advocate General. 3 weeks time allowed to the petitioner to bring on the additional documents. This thereafter, yes.
Lordship.
Yes.
May I please, Your Lordship, I beg to mention item number 54, Your Lordship. Let this matter be taken after 3 weeks, Your
Ricardo
Lordship.
Richmond Lalu.
Yes, Your Lordship.
Okay, after vacation or before vacation? Before.
After.
After. Yes. Okay. Yes.
Similar prayer for item number 55, Your Lordship.
Okay. After. Who's for the petitioner? Have you informed them? Which?
I have not.
Huh?
I've tried to.
You informed them.
Much obliged, Your Lordship.
Yes.
May please, Your Lordship. Also, I would like to mention to make one matter listed tomorrow, Lordship, due to urgency. That is Contempt case 29 of 2023, registered. I have filed last week, Lordship, and has been registered as Contempt case
Not
number
been listed
29.
as yet.
Not listed yet, Lordship.
Listed.
Obliged, Lordship.
Yes.
Main list, item number 1.
Immediately, Your Lord, we have filed a detailed counter affidavit.
When do you file it? Just now?
In the morning.
Just now. We have got the copy on the other side yesterday only. But filing has
They're supposed to file before the date, madam.
How do you expect the court to look at it then?
we
Now?
have.
We'll pose it tomorrow.
Actually, there are some documents. Lordship may have it tomorrow.
What do they say in affidavit? Anything of substance?
Well, basically, they're challenging the maintainability only on basically on that ground only, my lord.
What ground?
There are three things which
the
we are saying, my lord.
co-petitioner.
Yes, okay, start.
Just
Yes. What materiality point are you challenging?
The first point, my lord, is that locus of the petitioner to challenge this bid, my lord, because petitioner is not the bidder in this case. Consortium is the bidder, my lord. Consortium is the bidder. If your lordship will see the because I have relied on two judgments of the Guwahati High Court, because there also, in that case also, my lord, what has happened that it was it was the bidder which challenged that.
One second. Yes.
My lord, before the learned AG goes into this, my lord, I have only one very simple point to make, my lord. We are one of the consortium partner, my lord.
Right.
My lord, we have a major concern. Contract is one aspect of the matter, my lord. Whether if we are L1, we will get the contract. That is one aspect of the matter, my lord. The second aspect, and which is a more important aspect for us, is, my lord, the stigma of disqualification, my lord. Whether in the given facts and circumstances and as per the tender condition, we could have been disqualified, my lord. So, my lord, to answer that, the maintainability that other consortium partner is not a co-petitioner, my lord. In my humble submission, that is a secondary aspect, my lord.
No, I don't think so, Dr. Mozika.
Because disqualification,
because the thing is that, see, if the question, a basic question of locus, and if the bidding entity consists of two partners,
my lord,
and only one comes forward and the other rate as a respondent,
my lord,
that means a pro forma of supporting respondent, then...
but the only difficulty because the notice has not been issued to the respondent number 2, my lord.
We have not issued notice because we are trying to settle the matter whether you have the locus to maintain the writ petition. That's the only thing. So the court has some reservations about that, because if as per, what is that clause? In the tender?
My lord, that is at
page 74, the clause is there in
page 71.
If I remember correctly, there was some clause.
Yes, yes, sir.
Page 71, my lord.
May I proceed, my lord? If my friend is ready.
One second. Let us see. One second, Mr. Arvijan. Make a fan. The bidder participating in the bid as sole bidder, or the consortium member, or the lead consortium member of the bidding consortium, and a subcontractor should not be blacklisted. Okay.
By any government organization, regulatory agencies, or government undertaking. And the second clause, my lord, the subsequent clause, it says the bidder participating in the bid as a sole bidder, or as a consortium member, or as a lead consortium member, and its subcontractor shall not be banned, debarred by the MEPDCL and others utility, or any of its subsidiaries holding company, as on the date of submission of the bid. And then it says, my lord, bidder should submit a self-undertaking signed by an authorized signatories for the same as per the format prescribed in Form 7 given in Section 4. Now I pointed out the format, my lord. Your lordship kindly turns once again, my lord, to page 139, my lord.
May I raise first preliminary objection?
One second, Mr. I'm just trying to familiarize myself again with the facts.
Yes.
Not that we are deciding anything right away.
At page 139, my lord, clause 15, my lord.
Yes.
It says, but this is the undertaking to be given, my lord. We confirm that we are not currently banned, debarred by the name of the utility or any of its subsidiaries holding company. Now, utility here, my lord, is MEPDCL. Its subsidiaries may include MEPGCL, Power Generation and Power Transmission, my lord, and holding companies, Meghalaya Energy Corporation Limited, my lord. So, my lord, that particular clause read with the undertaking they are asking for, and we have given undertaking in terms of the Form 7, my lord. We don't talk about blacklisting; it only talks about debarment.
Yes.
And debarment by the tenderer, my lord.
Yes, Mr. Arvijan, what do you have to say?
Yes, sir, lord. Yes. The first point, my lord, is that the locus of the petitioner to challenge the petition, my lord.
Yes.
The short issue, my lord, is that if your lordship will see that there is no dispute that the bid has been submitted by consortium.
Okay. Yes.
Second aspect is, my lord, that consortium can challenge this process. Consortium can challenge debarment, my lord. That consortium has not challenged it. Third is, my lord, that the debarment or disqualification or holding the bid non-responsive has also not been challenged by respondent number 2, which is a consortium partner.
Yes.
So that debarment order has, my lord, to that extent attained finality. But I am coming back to the issue of locus, my lord. Kindly see the recent judgment of Guwahati High Court, which has dealt this issue extensively at page 37 of my counter affidavit, my lord. This is the recent judgment of my lord, Guwahati High Court, and this judgment, my lord, captures the entire aspect of challenge by consortium or challenge by one member of the consortium, my lord. And the argument which has been raised, my lord, at page, the objection which has been raised, similar objection has been raised at page 52, paragraph 14, my lord.
52.
Yes, page 52, my lord, paragraph 14. Mr. M. Deka, the learned counsel appearing on behalf of respondent 3 and 4, adopted the submission made by the learned counsel respondent 6, further submitted, entire edifice of the case of the petitioner is totally misconceived is in as much as when two natural or juristic persons join together forms an entity, and such entity is known as joint venture and has been held in Supreme Court in so-and-so decision, my lord, and the said entity would be legal entity in the nature of partnership and as could maintain writ petition. This is the argument, my lord, and the next page, my lord.
Yes.
Second line at page 50. Therefore, without the performer respond number 2(7) assailing the tender process as well as award of the tender made in favor of respond number 6, the petitioner alone cannot maintain the writ petition. And then, my lord, the issue is framed in paragraph 15, my lord. Whether petition number 1 alone can be said to be person aggrieved to maintain writ petition, whether the non-disclosure of sale, project division, etc. amounts to suppression of material fact. Now, the consideration starts at paragraph 16. Let this court first take into consideration as to whether petition number 1 can be termed as person aggrieved. The Supreme Court in the case of so-and-so observed that stranger cannot be permitted to meddle in any proceeding unless he satisfies the authority court that he falls within the category of aggrieved person. It is only a person who has suffered or suffers from legal injury can challenge the action, order, etc. in court of law. A writ petition under Article 226 of the Constitution is maintainable either for the purpose of enforcing statutory or legal right, or when there is a complaint by a person, then there has been a breach of statutory duty on the part of the authority. Therefore, there must be judicially enforceable rights available for enforcement on the basis of writ jurisdiction is resorted to. It was also observed that the court can, of course, enforce the performance of statutory duty by a public body exercising writ jurisdiction at the behest of person, provided such person satisfies the court that he has legal right to insist on such performance. Existence of such a right is a condition precedent for invoking writ jurisdiction of the court. It was categorically observed that it is implicit in exercise of such extraordinary jurisdiction relief prayed for must be one to enforce a legal right, and existence of such legal right is a sine qua non for exercise of jurisdiction by the court. It was also emphasized that legal right can also be enforced, must ordinarily be the right of the person agreed. Now, after dealing with this paragraph, my lord, paragraph 9, 10, 11, your lordship may take note of the Supreme Court judgment which has been quoted here in the my lord. Now, the examination by the Honorable High Court is at paragraph 17 at page 55. In the
okay, let's not read the judgment. The only thing is that this same thing is worrying the court also with regard, whether it's...
Well, not only one aspect. Well, I believe Mr. Yubin is there, is representing respondent number 2. If you can...
What's the problem in him supporting your case of filing as a consortium? Otherwise,
we are working on...
The thing is that you're tripping your own self on a technicality. The thing is that if you're really aggrieved, if the consortium really aggrieved, which you've put in your bid, then it stands to reason that you're legally and you're not severable. If you you've come, you're jointly liable for any action. Forget about the case now. Suppose anything happens, won't you be jointly liable? Suppose anything happens, it goes to arbitration. Won't you be jointly liable? Then at that time, can you sever it and say that, okay, my partner won't be liable for like claim 1 and 2 and I'll be liable? That can't be the situation.
I quite follow, my lord.
That if you bid as a consortium, then you're a juristic person. You attain a juristic personality, the consortium, correct? So
My lord, since respondent number 2 is represented, my lord, you can get their view.
My lord, may I just interject?
You not agree? You don't agree with the debarment? Okay, we allow you to submit. Yes.
So what I am asking is, my lord, today, kindly give him his time. Let him go through and let him come back, because it's very clear that I am supporting the petitioner.
Then if you support the petitioner, what stops you from, if on locus the petition is going to fail? It'll fail. That is what. That's the tentative view of the court. The other point, you might have a very good case. We got who's the utility in terms of the bid document. Correct. Whether utility of another entity will serve to blacklist you or to debar you. It's a matter of 2 days. Yes. Mr. P. Ubin appearing for has entered. Respondent number 2 is permitted to file an affidavit or make appropriate submissions.
Because 2 days will be Friday, my lord. If the matter can come immediately after vacation, puja holidays, my lord. In the meantime, we will file our rejoinder also.
Your choice. Yes. Heard Dr. N. Mozika, learned senior counsel with petitioner. Next scene, the affidavit filed by the respondent. Mr. A. Kumar, an advocate general, senior counsel, Parent Respondent Corporation has raised serious objections to the maintainability of writ petition on the ground of locus, specifically on ground of locus. Issue notice to respondent number 2. Mr. Yubin has entered appearance without respondent number 2. No further notice called for. This is matter after vacations for further orders. In the meanwhile, parties permitted to file their affidavits or rejoinders if necessary. Yes.
Otherwise, only that if any precedatory action is taken by them, my lord, render the writ petition infructuous.
Locus is not proved, and
because respondent number 2, it appears now is on board, my lord, with the petition.
I don't know. Appears on board, or it is up to you. How you manage your own litigation is your baby. Court's not going to
Item number 2.
Yes.
My lord, only thing, my lord, will render it infructuous, my lord. If the work is allotted in the meantime.
The result of the tenure process, or any tenure process entered into by respondent will be subject to result writ petition.
Deeply.
Petitioner is not agreed person. He has no locus.
See, in all fairness, the thing is that let's see, looking into the bigger picture, whether debarment, I've seen the clause just now.
Debarment, my lord, if I have not got the opportunity, debarment is blacklisted. Government of India. Government has said so, my lord. Now that is the picture. That is the only.
Item number 2.
No one's stopping you from going to tenure process. If you're on a good wicket, you go ahead. Yes. Yes.
So sometimes.
What's this?
My lord, this is an appeal against the order of the special judicial officer regarding in LA case number, my lord.
What document you want to bring on record?
My lord, I have brought it already.
Where
that
is
my additional affidavit, my lord, I have filed.
You've got a copy?
I've got a copy.
What's it say, Mr. Singhan?
My lord, this is regarding that establishment and contingency charges as regard to the land acquisition proceeding, my lord.
Regarding what? Sorry, cost of establishing contingency charges?
Yes, my lord. That is charged by the collector, my lord, for taking up that proceeding.
So, what is your challenge here?
My lord, we are challenging the order dated 31/10/2022.
What does it say?
If I can just.
So what does this say means? What do you agree with?
No, my lord. As far as this case is concerned, my lord, there was a notification under Section 4 of the Land Acquisition Act for that was in the year 2011 to acquire a plot of land for construction of house for Urbanpur under Integrated Slum Development Program. That is at Lower Moprem. And thereafter, my lord, after that notification, my lord, was published, thereafter land was immediately taken over by the collector, and then, my lord, notice under Section 12(2) of the Land Acquisition Act was, my lord, issued to the issued by the collector to the claimant, my lord, as regard to the compensation amount, my lord, and that was also paid. That amount paid was 67,38,032, my lord, and that amount was paid in 2 installments, my lord. My lord, the copy of the award statement is at page number 60, my lord, if my lord will come. Page number 60.
Yes.
Here, my lord, if my lord will come to page number 61 at serial number 7 at the top, my lord.
Yes.
It says amount of compensation allowed for the land itself without the trees, crops, building and structure, etc. That is 42,05,971, and the area was 919.74 square meter. That is 9,900 square feet, my lord. So if we calculate, it comes to 425 per square feet. That was paid to the claimant, my lord. Now, if we come to serial number 16. It says total amount of compensation payable to the person interested under this award is 67,38,032 rupees. This amount, total amount, was cleared to the claimant. And if my lord will come to serial number 17 at the last portion, my lord, establishment and contingency charges at the rate of 10% on the amount of so that is 6,73,802. This is the charge, my lord, which is given to the collector, which is collected by the collector, my lord. Now, total amount, my lord, that is page number 62. Total amount of this award, including establishment and contingency charges, that is 74,11,835. Now, as far as award to the claimant is concerned, he is entitled for 67,38,032, which was paid to the claimant. And the establishment charges, that is 6,78,000, that is for the for the collector, my lord. Now, what the learned special judicial officer, my lord, it held, my lord will come to page number 30.
Yes.
I will read out, my lord, paragraph 23. The assessment order of opposite party collector is found in page number 67 in the record of MUDA file. The compensation assessed by the collector was at the rate of 4573 per square meter. Total compensation determined was 74,41,397. Admittedly, the claimant was paid the compensation amount.
Okay. Do you retain the amount of contingency charges?
Right. And what is the ground? Why, my lord? And what what the special judicial officer held, my lord, is, if my lord will see the paragraph 24 of the judgment, page number 30 only, my lord. Albeit the compensation amount was agreed by the parties by tripartite agreement dated 15, that is to be 5, my lord, 5/12/2018. The claimant has annexed the agreement dated 5/12/2008 along with claim petition. It appears that there is an interpolation in the annexure 5 in the file of MUDA on perusal of the original agreement dated 5/12/2008 in clause J. The rates is blank. However, the same agreement is annexed along with claim petition annexure 5. Clause J is filled with handwritten rupees 650.
So the reference was on what point?
Now, my lord, that reference was, if I can just
to keep it simple, my lord, this is a reference code. Now, Mr. Gautam's client had gone to the reference code for enhancement. Enhancement was
not considered.
The court, in fact, goes beyond its jurisdiction and decides that this is not a land acquisition proceedings.
My lord, not
So
that
therefore, without any powers, takes away the 10%, which is the
collectors
for the collector.
Right.
So totally illegal.
Well, to cut it shorter, my lord, lordship will just come to page 29. 29. This is the paragraph 20. Now, what has happened here is, my lord, if the proceedings.
One thing before you. Was the land acquisition proceedings concluded?
Concluded.
Entire proceeding. Then how can he say it's not land acquisition proceeding?
Correct.
That is
the agreement. The agreement was never given effect to.
Okay.
It is thereafter that the proceedings.
Yes, Mr. Gautam.
My lord, what has happened is, of course, the reference was made under 18 and I wanted enhancement. enhancement not given to me, but at the end of the day, the court came to a finding that the entire proceedings was the award was based on an agreement between the parties. Now, when an award is based on the agreement between the parties, Section 11, Clause 2 of the old Act clearly says that the court, if Your Honor has the old Act, my Lord has the old Act. I'll just read paragraph 20, my Lord, to make it. The compensation awarded to the claimant is an amount of such and such, after deducting the incidental charges amounting to such and such, was retained by the collector that from the record it emerges that there was a meeting on 10/10/2011 and it was resolved that the rate of the land was found to be above 700 square feet. The tripartite agreement was entered on 5/12/2008, which is indicative of the settlement arrived by the parties on the consideration of the land. Now, when there is a settlement between the parties, my Lord, the award, the question of deducting incidental charges does not arise.
Still out, who's? AG is arguing out a case.
Some other court. Cross connection.
This is
time lapse.
Mr. Amit Kumar, can you still mute other proceedings? This is.
So, my Lord, now I'll just read Section 12, Clause 2.
For admission hearing today?
My Lord, only for admission hearing.
Interesting point.
Record may be called.
All are served. Record necessary.
Record is necessary.
Record will be necessary.
Yes, heard counsel for the parties stop. List admit the instant first appeal. Stop. Records to be called for from the court below. Matter to be listed on receipt of records.
One technical problem. Respondent number 2. Respondent number 2, Director, Urban Affairs, Government of Meghalaya, should have been an appellant, joint appellant.
You're a performer?
Challenged by the collector. Performer, yes.
Your performer doesn't matter. Yes.
Item number 3.
Yes. Dr. Saraf.
I'm appealing for the petition in this matter.
Yes.
Lordship, the respondent number 1 to 4 have already filed their affidavit in appeal. They filed it yesterday, Lordship.
Yes.
Lordship, we would like to go through the affidavit and file a reply, Lordship.
When? How much time you want?
Lordship may give us 3 weeks time, Lordship.
Okay. You are Mr.
I'm S.J. Soikia.
Or Mr. Soikia, please for around 3 weeks and for the joint affidavit filed by the respondents number
1 to 4.
1 to 4 is.
Respondents 5 to 7 will be filing an affidavit in the course of the day.
MSZ on behalf of the respondent 5 to 7 submits that the affidavit will be filed in the course of the day. Less after 3 weeks. Yes. Less also and so. Yes.
Item number 4.
May it please your Lordship, I am appearing for the writ petition. This is a writ petition file and there is also an interlocutory application. The Lordship would recall this is that matter where a resolution plan has been filed and the state is contending and claiming dues prior to the CIP period, which your Lordship has passed an interim order. And subsequently, we have also taken out an interlocutory application where we contend that in spite there being a Lordship's order, no course system, my existing electricity to my existing sites are not being provided for, which the last occasion your Lordship indicated or directed the state to at least come with the instructions vis-a-vis. I do note that the issue raised is a final hearing matter, but the interlocutory application was being considered.
Mr. Sastry and argued this interrogatory application earlier also, the Lordship has been pleased to fix this matter for final hearing, and I can show on the basis of resolution plan that statutory dues have not been billed. We have also raised some preliminary objections as to the maintainability. The matter has to be finally heard, my Lord.
Where's the miscellaneous place?
And also one more thing I just want to indicate, your Lordship, on the last occasion, the interim order which was continuing was not extended, your Lordship. There was an interim order which was there. While I will make submission of the interlocutory application, I would request my learned friend to address the point of maintainability.
No, forget about that. For the time being, now last order passed in the application at 1-9. Now,
yes.
Mr. Advocate General, the thing is that what decision did you take on their pending applications for fresh connections?
The issue
Have you answered that in affidavit?
Your Lordship, in the affidavit we have answered all issues, including their interim application also. The reason or the submission we have, my Lord, is that they are not entitled to the correction unless they clear the statutory dues. And their whole case is that the resolution plan has been approved, and therefore once approved, resolution plan has been approved, all statutory dues are waived.
No. Their submission, if I'm not mistaken, is that they are clearing their current dues. Correct. So they want fresh connections to their. That they will service these current dues. What is your reply on whether they can be allowed fresh connections or not? That's all.
No, Your Lordship, the issue is that unless they clear their previous dues, they are not entitled to have fresh connection. If that proposition is accepted, my Lord, all defaulting consumer will come and saying that I will not pay my previous dues and give me a new connection. So therefore, that first the entity has to clear the past dues. And therefore, and if it is not, and what entity is taking or the petitioner is taking shelter of is the order passed in the resolution plan, where the resolution plan, the petitioner has been declared successful. My first submission, my Lord, is that even resolution plan also does not save the statutory dues. Second is, my Lord, that under the IBC code, what the petitioner is trying to seek through writ petition is to implement the order of the NCLT approving the resolution plan, my Lord. IBC code provides that in case there is a dispute that the petitioner can approach the NCLT, my Lord. So these are the two limbs of submission, my Lord, basic limbs of submission. And third, my Lord, there are certain developments which have taken place, which have been noticed in the rejoinder by the petitioner says that now the petition number 2 is merged with petition number 1. So necessary amendment to the writ petition is required to be carried out. My Lord, if you also will see the rejoinder also. The rejoinder petitioner has taken a stand, my Lord, that now there is a merger. If you also will see.
Which page?
Paragraph 4 of the rejoinder, my Lord.
Paragraph?
4 of the rejoinder.
Excuse me.
My learned friend is referring to page 3. I'll explain that.
Page 4.
I state that subsequent to filing of
Para 4, page 2.
Of events have unfolded, which the petitioner wished to bring to the kind knowledge of this court. Pursuant to take over an acquisition of petition number 1 by petition number 2, and so, petitioner has filed a petition for approval of a scheme of amalgamation under so and so, seeking merge of petition number 1 into petition number 2. By order dated 11th May, Honorable NCLT Mumbai was pleased to approve the scheme. Pleased to approve the scheme with effect from 22/12 by an order dated 7th August. Honorable NCLT was pleased to approve the scheme. So there is an amalgamation of petition number 1 and 2. So they are not two different legal entities. So therefore, necessary amendment in the writ is also required to be carried out, because petition number 2 is in existence. Petition number 1 is because seek to merge petition number 1 with 2, my Lord. So now the petition number 1 is not in existence. So a necessary amendment is also required to be carried out by the petitioner. And then we also have to examine whether petition number 2 is covered under the resolution plan. If it is covered, whether it is the amount due and payable is waived under the resolution plan, and is supported by IBC code, regulation, and judgment of the Honorable Supreme Court. My friend has also cited few judgments, my Lord, but the core issue which falls for your Lordship's kind consideration is whether without clearing the previous dues, petitioner is entitled to fresh connection or not.
No, the thing is that, see, I think their case is on the basis that as per IBC code, after this resolution, all creditors will be bound by the orders of the NCLT. That's the basic stand, I think. And so on the basis of resolution, they're saying that, okay, fine, the operations have to continue, so give us fresh connections to allow us to operate. And basically, I think that is the whole question, correct?
Yes, sir.
Yes.
Kindly see the writ petition at page 235, Lord. 235 writ petition. What is the resolution plan saying, Lord? 235.
Yes.
and small Roman 3, your lordship may kindly see.
Okay. So you're talking about statutory dues.
Yes,
One
my
second.
lord. My case is that it is statutory dues under the Electricity Act, my lord. And once I come under even if there is no waiver, in my humble submission, there is no waiver by this plan.
Or statutory dues.
Yes, my lord, there is no waiver. And if your lordship will see my counter affidavit on this aspect, my lord, paragraph 6, I have also taken a plea that the IBC code itself provides, my lord, paragraph 6 at page 2.
Yes.
Because the petitioner, at last 3 lines of my paragraph 6, the petitioner has alternative efficacious remedy in as much as section 65 5C of insolvency provides as under. Any question of priority or any question of law or facts arising out or in relation to the insolvency resolution or liquidation proceeding of the corporate debtor or corporate person under this act.
Okay, do one thing. Mr. Shastri, you ready with the matter today?
Your Lordship, I'll just indicate, I am ready with the matter. My learned friend has made the points before without even overview and examining the correct position of law. I would say the cat is out of the bag. 2 things I'll just indicate. My writ petition is where I contemplated stating that the petitioner number 1 undergoing CIRP is not liable to make any payment of dues of a cut-off date. There is a cut-off date. When we receive a demand notice, we indicate you please specify on which dates you are asking for dues. You have to categorize and clarify. And we say after the cut-off period you are entitled to. This demand notice has been made, no response. Second point, my learned friend is taking a shelter of a plea, maintainability of the writ petition, and also relying on a judgment of the Honorable Supreme Court in Rainbow Mills. But what is not being told by learned friend is that that judgment has been subsequently considered by the Honorable Supreme Court and has been clarified, stating that if the dues pertain to a particular CIRP period is not payable in terms of the waterfall mechanism. Your Lordship, today, kindly appreciate, today I receive a demand notice of 12 June 2023. They enclose a list of 145 towers with me and say these are the dues pending and these are there. I reply to them and say, look, there is a CIRP process in which operates, the resolution plan has been confirmed. The resolution plan order approving operates in REM. We say prior to the date, these are not payable. Post date, we are ready to pay. Till date, that representation has not been answered by the state. Now, see the mischief. The mischief is that your lordships, after considering, passes an interim order, no coercive steps. Now, the expression no coercive steps is being taken to use where I go and say, look, I have now my pending tasks which are operating. You process me fresh electric connection. I am ready to pay. Nothing answered.
Our stand is very clear that they are liable to pay for previous dues. The resolution plan has no waterfall mechanism. What my friend says, I have shown me lot statutory dues. The even resolution plan clearly says that statutory dues are not waived. So what more I am required to say when I say that these are statutory dues? So therefore, my lord, in my humble matter has to be heard finally. Lordship may have it in the first week of November. I will argue, my friend will argue, and then I will show that my rainbow judgment is squarely covered. That judgment has not been distinguished. What my friend is saying, that judgment, I have got that judgment in my favor. So therefore, in humble submission, this requires consideration, my lord. What my friend is saying that
exactly this requires consideration. Let my learned friend start. For the last 3 occasions, every time they say they will file an affidavit in opposition.
I have already filed it.
So I am objecting to it. I am being suffering from August.
You know, I am ready to argue the matter. I have no issue.
Let him start on the maintainability.
Yes. Oh, sorry.
Yes, sir.
What were you all both saying?
Yes, my lord.
Yes.
We were on the issue as to the maintainability, my lord. As to the maintainability.
Yes. Sorry. I was just looking at something else. Yes.
Yes, your lord. What I was saying, my lord.
No, you're saying you're trying to implement the resolution through writ petition. That is your submission.
Yes.
That so that is not maintainable. That's not permissible.
This is my
and then there stands that as per the approved resolution plan, is binding on all. and the petitioner liable to pay the debts claims prior to 22/12/2022. Correct?
Yes.
So prior to that, before resolution plan, they say that whatever dues are there, they're not liable to pay. Right? So now the only thing, the consideration they're asking for is that, post that date, now that they're running their towers, they want electricity, that's all. And is that the case? And statutory dues, you say, won't be covered under the resolution plan.
Yes, sir. So alternatively, my argument is alternatively. First, these are the two submissions you got.
Yeah, and then their stand is that section 31 clause 1 of the IBC code says that all creditors will be bound by that resolution.
And yes, Lordship, and alternatively, my lord, statutory dues are also not waived under the resolution plan. That is my alternative argument, my lord. If the Lordship takes a view that no, the writ court can enforce the resolution plan, then in that event, my argument is
it's not imposed. It's maybe recognized that it's gone into it's gone into the approved resolution plan, right?
Yes.
So then, because it's a commercial kind of situation, and so courts will be alive the situation also, right?
Yes, Lord.
So now what? Now where do they stand now? The only prayer they have is that, look, do not saddle us with the dues for the earlier periods. There's a cutoff date. Now after the cutoff date, you give us fresh connections and we'll pay whatever dues are admissible. That's all.
My case is that the cutoff date is not applicable. They are liable to pay for previous dues. Those dues have not been waived under the resolution.
Then we'll have to hear this matter.
That is on merit. That is on merit, my lord. That is on merit.
When day after tomorrow? Will you be physically available here? Now, and Mr. Sastry says the rainbow papers has been distinguished.
Wants to do physically. I want to only accept after Durga Puja vacation. Today is the last Calcutta High Court working day, and it opens after 20th now. That's the only indulgence I am seeking from my learned friend. I have never opposed any of his accommodations.
Because interesting point. Yes.
Only one thing. I'll just draw your attention to page 286 of my writ petition.
Yes.
This is all they have.
There can't be any kind of via media with regard to towers necessary to be doing the pendency of the writ petition. If the earlier order is there, now will this amount? One thing, Mr. Amut Kumar, will this amount to coercive action? You denying them the fresh connection?
Yes.
And non-consideration, not denying, non-consideration of the fresh connections, will that amount to coercive action or not?
No, my lord. That coercive, we are not making an effort to recover as of now. What we are doing is that we have, because those dues are pending against petitioner number 1. Petitioner number 1 or 2, whichever entity is in existence.
Correct.
Yes. That is not clear by the state government. Kindly comes to page 286. This is all has to be addressed.
Okay. 286 LOIs.
Of my writ petition.
Right. 286 a judgment.
Petition, Your Lordship, this is, no, Your Lordship, 286.
Okay, yes.
Letter on the last page I have, which we ask for this. Provide details of all dues payable under by RT includes the principal, the period for which amount due and payable not provided. Withdraw any demands for this prior to this and not to take any coercive and its properties being done. Not to take any measures against this and permit installation, not being done. I am only saying today, the Lordship kindly considers this is the ensuing puja vacations which are coming. Today, let them process, let them identify the cutoff date. I will pay from this period to this period, and you provide the corrections. The only sum and subsidy
all defaulting consumer will come and say that
I am only asking for an interim measure.
I don't think, Mr. I don't think their case is similar to the others. I don't think so. This court doesn't think so, rather. Where's an interim order passed in the MIS case?
On the 1st August, Your Lordship. 1st August.
Not 1st August.
22nd December.
1st September.
1st November.
See, this order still stands, 1st September.
Yes, sir. That order is no coercive. We are not taking any coercive action to recover.
No. The order of 1st September says that, you kindly see, This is the so and so after instructions. The court further directs that positive instructions should be obtained for next date as to the fate of the application of fresh connections, notwithstanding outstanding dues that are present with subject matter and remain in petition. Now, I just take down Mr. Sastri.
We have said in the counter
Yes, sir.
that they are liable to pay all dues.
Yes. Okay, just listen to the order. The matter was heard at some length, but as other larger issues remain to be addressed, the parties pray that the full-fledged hearing be allowed after the puja vacation stop. Mr. Shastri, counsel to petitioner, has however drawn the attention of this court to a letter dated 26 July 2023, wherein the petitioner has categorically sought certain clarifications which are contained at page 286 of the writ petition. He submits that the same has not been addressed. Mr. Next paragraph, Mr. A. Kumar, the Senior Counsel on behalf of Foreign Corporation, submits that no course of action is being taken, and all the requests of the petitioner shall be examined in due course. This court, on hearing submissions and on examination of the queries raised by the petitioner with regard to details of all dues payable by the petitioner, including the principal amounts and the periods which months are due and others, demand a reply. In fact, require a reply from the respondent corporation. Especially with regard to requests number A and B.
We are saying that we will not withdraw.
Okay, A, especially with regard to A stuff. Next paragraph, this matter after puja vacations, a written affidavit should be filed addressing the request number A as given here and above by the next date. Yes, this accordingly also. You take a date.
Your Lordship, that interim order may be continued in the next date, Your Lordship.
Which interim order?
That interim order
first. It's already lapsed. It's still the next date. They put in a fresh application. Yes, next matter.
Item number 5.
The interim order of no force because it was continuing every time.
No, they weren't taking a course of action. Yes. Okay, it's understood that as ordered earlier, no course of action will be taken by the respondents till the next date. Yes.
Yes. Hello, Your Lordship.
Five.
It pleases Your Lordship. Yes, Your Lordship, this matter is still pending in the Supreme Court.
What matter is this?
Border issue, Your Lordship.
Humbly, yes. Counsel submit that the matter is still pending consideration of the Honorable Supreme Court. This is a matter of 6 weeks.
Obliged, Your Lordship.
6.
Please, Your Lordship. Your Lordship, I'm requesting for a short accommodation. Actually, Your Lordship, this matter was being heard with election petition number 2 of 2023. And on the earlier occasion, Your Lordship has reserved the order. So, Your Lordship, all I am requesting is to accommodate me so that because a note is also to be filed, Your Lordship. So, in the meantime, I will file a note in Your Lordship. Detailed note
was on 7-11 application.
Yes, for the proper assistance.
Yes.
So they were required to file a bullet point to indicate what exactly.
You have not filed it as yet.
But, Your Lordship.
You have not filed bullet points.
That's what Yes, Your Lordships, I'll be filing a detailed note in this matter, Your Lordships, and because this matter needs extensive hearing, Your Lordships, all I'm requesting is to kindly accommodate me so that I can properly assist this Honorable Court, Your Lordships.
Then you come for oral hearing then, on the next date.
But
when?
Please, Your Lordship.
When?
Your Lordships, anytime.
Immediately after Puja, my Lord.
Because Your Lordships, Your Lordships can.
Yes, stop.
In the month of November,
yes. So also prays that as the matter requires further hearing, that the same be fixed out of puja vacations. Request accepted. List after so and so.
7.
Yes.
May I please, Your Lordship? Your Lordship, in this matter also I'm praying for some time.
It's fixed for hearing on the 7/11 application, Your Lordship.
Why? What
Your Lordship, the
objections have you raised to 711?
The conducting counsel is indisposed, Your Lordship.
Who's the conducting counsel?
Devender Sharma, Your Lordship.
Okay, after adjournment application has been made, you've seen the adjournment application stop. The ground set out is that the conducting counsel is indisposed. Accordingly, this is matter. Accordingly, adjournments allowed. List the matter after. Also, yes.
Much obliged.
Item number 8.
Enter appearance for the respondent. So I request.
You complied with the order. What's the order?
The order is for regularization thereafter to release all.
Let's see the order. Is it very difficult to comply with, Mr. Zarika?
Yes.
What page is it, Mr. Samin?
Page 11, Your Lordship.
Page
11. Operating portion is page 13.
Yes, this is already confirmed in service.
Yes, already
Then?
confirmed, regularized.
So when how long
pension
will it
matter
take?
also.
Mr. Zarika's enter appearance on behalf of the sole respondent.
No, my lord, two.
Two respondents.
Both
one
the
and two.
respondent.
Both respondents stop. The pre-response is allowed 2 weeks time to file affidavit. List thereafter. It's expected that the order, because okay, after 2 weeks, I'll say orderly you comply with it. Otherwise,
No, it is already
it's a very clear order.
Already, because the pension is already given, my lord.
9.
Only some objection from the AG. Much.
Please, Lordship. I have filed a rejoinder, Your Lordship.
Already filed.
Of the respondent
Very
number
good.
4. The other respondent I am not
You won't
going to file because I will rely on the affidavit filed.
Yes, party submit that applications are complete. This matter
Yes.
for hearing after puja vacation.
Lordship.
Also, so yeah.
10.
Not rest, Lordship.
10.
Wait, please, Your Lordship. Your Lordships in items 10, 12, 14, 17, 18, and 20, we have filed our affidavits, Your Lordship.
Where please?
10 to 20
Which
are
one? Which
connected
one I haven't
matters.
filed?
In items number 10, 12, 14,
No, which one where you haven't filed?
No, I
haven't.
It's connected matters, Your Lordship. 11, 13, 16 affidavit filed.
So all are filed.
Just two more, Your Lordship.
Who hasn't filed?
Just two more affidavit are yet to be filed.
From whom?
From the respondent, state respondent.
Which cases? Which offer me which one? WPC number what? Kumar.
What is this number?
Who the appearing 96 and 100? WPC 96 who the appearing 96?
96.
Who's the appearing 100, 96 and 100?
96.
I am appearing 96. I am appearing.
Why haven't filed affidavit?
I'll file it.
Go to the day. 100, who's appearing? Who? Who's filing 100? Is officer Iriki has not been filed? On WC 100?
Already filed. Have you filed item number?
We filed.
We filed.
Check 100, WC 100. Check it. And say WC 100 the same also. I can remember. Sorry, it's not here. Where do you file it?
In that case, I pray for 2 weeks' time.
Officer indicates that has been filed in RPC's number so. Mr. H. Kharmi appearing in WC 96 of 223 and Mr. Hargurung appearing in WC number 100 to 23. Pray for allowed 2 weeks further time to file affidavits. This thereafter and so. Rejoinder?
We may be allowed, Your Lordship, to file a rejoinder.
Yes, so also praise allowed for rejoinder to the affidavits. Praise allowed.
Obliged, Your Lordship.
Twenty-one.
Your Lordship, we are praying for some time to file a
Have you seen that letter?
Yes.
Very strangely enough, you ought to have by way of affidavit if there is anything.
So what are you going to do about that?
So far we are concerned, government stand is concerned, their claim is that the teacher who has been appointed by the secretary, by the school managing committee, the post in which she's been appointed is a Hindi. Now the government stand is that the Hindi subject is not sanctioned. It is not a sanctioned post. It is not a sanctioned post. It has been exclusively appointed by the managing committee on their own. Because so far the SSA scheme is concerned, it allows for appointment of 3 sanctioned teachers. You see, in our affidavit we have you
file affidavit?
No, we have filed affidavit.
We want to file rejoinder, Your Lordship.
The affidavit?
Yes, Your Lordship.
Let them file rejoinder. Where's the senior?
Video conference, Your Lordship.
Yes, so and so prays for allowed to file reply to affidavit file with respondent number 123. Yes, option so.
Which night, Your Lordship?
22.
Please, Your Lordship. Lordship, I filed affidavit.
Who's been with the petitioner? Who's the petitioner?
It's enough.
None appears not a petitioner. This is matter for 3 weeks. Yes.
Much obliged.
23.
After on behalf of your respondent, Mr. Bhumik, respondent number? 4.
Number 4.
Noted that affidavit on behalf of respondent 4 has been filed.
Much obliged.
Yes, Mr. Chaudhary, why heavy artillery?
May it please Your Lordship.
Yes.
My Lord, we are basically seeking an inquiry, my Lord, into the matter. Now, admittedly, my Lord, by their own affidavit, in fact, by filing the affidavit, our task has been made easier. Now, apparently, my Lord, there is a report for initiation of a proceeding under 107 and 145. In such a scenario, my Lord, what was the scope of entering somebody's house, my Lord, smashing the mobile phone and my Lord, destroying the CCTV cameras? And then what was the complaint? Well, by filing the affidavit, our task has been made easier. Without search warrant, can police enter our place, my Lord, and do all this?
The law takes its course, Mr. Chaudhary.
No, my Lord, there are 2 aspects. No.
Your conduct also.
No, my conduct, no, my Lord, my conduct may attract a proceedings under 107 or 145. And that, my Lord, the learned executive magistrate has not initiated as of date. There's a report only. Now, my Lord, all that we are assailing is, where was the scope for respondent number 4 to enter my premises, enter into my privacy, ransack my house, destroy my properties, and take away my mobile phone, my Lord? My Lord, I am not saying. If I intend to initiate any criminal proceeding, I'll file a complaint. If the police do not, take action, I'll move the magistrate under 156(3) of this CRPC. That's a different aspect. Here in the administrative law realm, my lord, in the public law realm, I'm seeking an inquiry into the whole matter. After all, he's a public servant, my lord. How can he behave like this? How can he take law into his own hand?
What's your prayer, Mr. Chaudhary, in the decision?
My lord, will kindly have a look at the prayer, my lord. Why a misdemeanor should not be issued, directing respondents to initiate an inquiry into the incident and to stop ongoing illegal atrocities upon the petitioner and their children. Kindly see, my lord, the wife was alone with 2 minor children and cops entering, somebody's house and doing all this, my lord, unlawful activities.
What if
respondent number 4 is...
what have they said in the affidavit?
My lord.
You said the affidavit proves your case. What have they said in the affidavit?
In the affidavit, my lord, they say, in substance, they say the police went based on a complaint of the landlady, and my lord, some actions were taken. Now, if your lordship would kindly come to page number 52, my lord.
Of the affidavit.
Of the affidavit filed by the state. Please come to, my lord, page 54.
Okay.
Now, this is apparently the complaint. Page 54. The prosecution story of the case is that I received a written complaint from Srimati Sumati De, so and so, to the effect that Sumit Kumar Jain Vora, that's the petitioner number 2, is the son of our tenant Sri Suresh Kumar Jain Vora, and Sumit Kumar Jain Vora is violating the rent agreement and forcibly doing the renovation work in her rented premises without her consent. She tried to stop, but all in vain. Moreover, she gave him the building on rent to Suresh Kumar Jain Vora, who was also opposed to the renovation work. It is also mentioned that Sumit Vora had locked the gate of the terrace and she cannot go to her terrace. This was the complaint, my lord. Apparently, it is a private dispute.
No, but what is civil dispute? Is any title suit pending?
There is no civil suit pending.
There's no suit pending.
Title suit keep prayer.
Then let it go to a civil suit.
It should go to the civil suit.
No, my lord.
You won't understand, Mr. Chaudhary. This is because if it's a family matter, and then
it's not a
directing
question
for
of
inquiry by the.
If it is a family matter, what business respondent number 4 had to visit my place, my lord?
So you want to be punished?
Of course. And my lord, he has, having received notice, he has not even filed the affidavit. Let him at least, my lord, Supreme Court has said, my lord, when allegations are very serious, lordships will take note of the affidavit filed by the guilty officer. He has not filed his affidavit as of date. Let him file his affidavit. No. He has not
filed a joint application.
No, it can't be a joint.
Party by name.
Yes, his name. Respondent number 4.
In fact, your lordship, he was authorized by superiors to enter the
Let
premises.
it come affidavit.
Yes.
If it shows that yes, he is acting the orders or whether it's a sovereign action on his own part, then we'll see.
We have enclosed the authority letter also,
my
whereby
lord
he was
will kindly see.
directed to a court there because the officer in charge of the Tura PS was on
When he
leave.
we should have filed a personal affidavit. He received notice, correct?
Yes. No, my lord will kindly come to page 57. Why the affidavit is necessary, my lord? Now kindly see what he says. Lordship has noticed the complaint that terrace is locked. Now please come to page 57.
Yeah, page 3 is there.
Brief story of the case is that, has your lordship got it, my lord? Page 57.
Yes.
The brief story of the case is that on 5/7/23, the first party noted in column 3 appeared at PS and verbally reported to the effect that they were mentally tortured by second party noted in column 4 since January 2023. Some of their rooms were locked without their permission. Even on the contrary, my lord, earlier the complaint is there was a written complaint and complaint was the terrace was locked. Now I kindly see, my lord, a different version. During a spot inquiry accompanied by CI so-and-so, that's the respondent number 4, and so-and-so, it is found that second parties who were son and daughter-in-law of the first party are always against them for petty issues and always lock their rooms and connected gates which affected for others in the daily needs. The first parties were again against installation of the CC camera, a TV camera in every corner of the building, stating that he has no privacy for them. Accordingly, the first party broke open the key lock, dismantled. No, my lord, it is the police officer who has, my lord, dismantled and damaged the CCTV camera. These are all, my lord, covered in videography, my lord. That's why I've also filed an application, my lord. Let it get it done, tested by the forensic experts.
Not
in terms
necessary.
of, no, I'm just saying.
Let him file an affidavit. We'll see.
We'll file an affidavit. For respondent number 4, your
Both are
lordship.
inclined to order inquiry also. But any action taken against erring officer, that'll be done. But
No, my
no
lord,
inquiry.
lordship will kindly appreciate. It's a question of entering into somebody's privacy.
This is not the correct forum, your lordship.
In fact, this is the only forum. If it is a violation of administrative law principles, then this is the only forum.
And all these allegations are false, your lordship.
Yes, please, this
against
is
the
order.
respondent number 4.
Yes, heard Mr. K. Chowdhury, counsel for the senior counsel Prisha, assisted by so and so. Also, MSD AAG with so and so. Stop. It appears that the next paragraph. Attention of the court has been drawn. The attention of the court has been drawn to the senior counsel the affidavit filed by the respondents, where it is, and it is submitted that the respondent number 4, who is alleged to have broken the CCTVs to meet respondent by name
And taken away my wife's mobile.
Has not filed an affidavit. Accordingly, stop. Court has perused the affidavit. It is submissions of the legislative counsel are correct. Accordingly, stop. Accordingly, respondent for that to file a personal affidavit before the next date. This is the matter and so for further consideration.
Deeply obliged.
Why did you have to bring heavy artillery just for this case? Must be stakes are very high, Mr. Chowdhury.
My lord, will kindly appreciate, my lord. I have to leave Trura, my lord. Now I'm staying in Guwahati. This is the extent this respondent number 4 has gone. That's why we are insisting on it, my lord.
Okay.
My lord, my kids are asking.
Don't expect anything from this court. That's all. It's a civil dispute.
It's just a frivolous allegation against the respondent number 2. They are trying to obstruct.
Yes, all ego hassles, yes.
This investigation.
Yes. Yes.
24.
Mr. Nath, where were you in the earlier matter?
My lord, I was just outside. I entered this, so
having tea.
I was just waiting outside. I'm sorry, my lord.
Rejoinder?
My lord, in this case, we are in course of the day will file. It's already ready.
Mr. Ichana submits that rejoinder will file in the course of the day. List this for hearing after Puja vacations. Any other respondents?
No, there's
25.
Please, Lordship. Lordship, in this matter, Lordship, I have prepared the affidavit on the basis of the Prohibitions comments received from the SDSEO and forwarded to the director for signature, Lordship. But last week I received another Prohibitions comments from the
you want to
director.
follow up your communications?
No, Lordship.
Then? You want the instruction complete, Mr. H. Karmi submits that additional instruction has been received. Please may not further time to file affidavit.
I have received and prepared. I'll file it immediately.
This after 2 weeks. Yes.
26.
Yes.
I am being led by the Advocate General, and he is appearing before the Supreme Court in the Meghalaya teachers matter. I am requesting if the matter could be taken up after the Puja vacations.
There's an interim stay operating, Milids.
Stay?
Your lordships have stayed the further proceedings.
Let it be. Doesn't matter. Doesn't have any adverse effect.
What is happening, Milids? The only difficulty is 5/12/2022. There is an order, Milids, passed by the Commission directing the MEPDCL to raise the bills as per the special tariff. Now, in essence, Milids, this order is a reiteration of the order of 5/12. Now, they continue to raise the bills as per the new tariff and not the special tariff.
Let us have it done tomorrow or the after.
I'm sorry, Milids.
The after?
Day after tomorrow.
Day after.
36.
So this is. It's like when you telephone before landline, you get cross connections. He's speaking with someone you don't know.
But I'm appearing for respondent number 2 in this particular matter, my lord.
Yes. Where's the affidavit?
We don't. We have already declined.
Oh, he said no for.
Your lordship, I'm here on behalf of respondent 1 will not be filing any affidavit.
2, no affidavit. 3 and 4, yes, Salam.
36.
Lordship, I need some more time, Your Lordship, to file affidavit.
Where's the petitioner? None appears the petitioner. MSS Rumthau submits that on behalf of respondent number 1, No affidavit forthcoming. Stop. MSS Sharam, page 3 and 4, page 4 is allowed 2 weeks for the time.
Lord, I'm appearing for respondent number.
Yes, it's recorded. Don't worry. Yes.
37.
Six. Who's for the petitioner?
My lord, please, my lord.
Yes.
My lord, service affidavit already filed, my lord.
On 6 served?
On 6, my lord, yes.
6 has been served?
Yes, my lord.
Mr. S.K. Hassan submits that the senior service affidavit filed, which indicates that the respondent 6 has been served. Stop. However, none appears on his behalf. Yes, what do you have to say, Mr. Sheikh?
May I please, Your Lordship, I also need 3 weeks, Your Lordship.
So next paragraph, MS Barisaji for 1 to 5, SC Sheikh for 7, Pray 4.
There is an interim order, my lord. Kindly extend.
Allowed 2 weeks for the time for affidavit. Stop. List the matter after 2 weeks.
3 weeks, Your Lordship. Kindly, last time.
3 weeks, yes. For affidavits for appearance of respondent number 6. Interim order passed earlier shall continue.
Order was lapsed.
Order lapsed?
No, my lord. My lord, last occasion only, my lord. Prior to that, my lord.
Oh.
My lord, 6 months is the life, my lord.
Who said 6 months is the life?
My lord, as per
Next date till the next date, lordship.
my lord, in 6 months, if court is not, my lord, extend the order, my lord, in general terms, my lord.
Show me the ruling. Where does it say
It was
that?
during COVID time, Your Lordship, it was.
No, you can't. What submission is that?
My lord, I'm just praying, my lord. My lord, last occasion only, my lord, that order was not extended, my lord.
Yes?
Till
My
the
lord.
next date, the order, the validity of the order is till next date, lordship.
So now during puja he'll do some mischief. What is he going to do?
Yes, my lord. But after the passing of the interim order, my lord, the SDSU has also passed the order.
Like considering the nature of the matter, stop, and on the prayer of Ms. S.K. Hassan, the interim order passed on 17/8/2023 shall continue to the next date. Give them a puja bonus.
Highly obliged, my lord.
38, my lord, 38 and 39 are connected matters.
Yes.
The respondents are to file their affidavits, my lord.
My lord, I have received my instruction. I will be able to file by the puja holiday. When the court will resume, my lord. When the court will resume after vacation, my lord, the affidavit will be able to be filed.
Yes, Your Lordship. Lordship, I'm for respondent number 5, Your Lordship.
Not filing.
I'll be filing, Your Lordship. Okay.
MS Arkoni 1 to 4 and M. Bisnai Tang for 5. Pray for allowed further 3 weeks time for affidavit. Okay? This is also.
38 and 39.
40.
What matters?
40. Your Lordship, I'm appearing on behalf of respondent 1, 4 and 5. I would be requiring further 2 weeks time, Your Lordship, since
No, but last time you only said you already been paid, Mr. Marpan.
Specific instruction, Your Lordship, as per they are submitted. I was appointed 84, so their dues which you have cleared is from 99 till 2021. The 84 till 2099 that I have not received. I can clarify that they are correspondent, they are letters and all. After they file an affidavit, I can clarify that.
Last time I made a submission, they said whatever dues
Your Lordship,
papers already been paid.
that is what I was being told by the department, Your Lordship.
But now it's not true.
Your Lordship, we're just awaiting the annexures since we've sent it back for the type
Part of
copies,
it is
Your
true,
Lordship.
what have they submitted is true, but 84 till 99 I have not received.
Marpan, Leonard Council Petitioner submits that though some dues have been paid, the entire amount permissible is yet to be released. Next para MS Thao for 1, 4 and 5, so please be allowed to file a detailed affidavit before the next date. Or no affidavit from your side.
2 and 3 was waiting for instruction.
Yes, Jong Arkong Thao. When the next day stops, similar prayers made on behalf of MS Arkoni power respondents, list on so and so. For affidavit.
41.
Please, Lordship.
Yes.
Lordship, on the last occasion, Lordship was kind to give me a chance to file a short affidavit. Some more time is required, my Lord. After
No. Maintainability, you should be,
Lordship,
what did he say in the thing?
Practical difficulty, my Lord. The respondent number 4, his father-in-law expired. He's in Bihar right now. We'll file it immediately upon reopening, my Lord. He's back next week.
You have no objection. What question maintainability? Why?
Because Lordship will see the petition which has been filed is purely a petition to recover money, my Lord, or to enforce a contractual obligation. According to them, that we had promised a certain amount in lieu of the land. Certain amount, according to them, was not paid. They want intervention of this honourable court. That is the matter for a civil court, my Lord.
Your Lordship, on behalf of respondents 1 to 3, also I'm going for time to file an affidavit.
What about he appearing for? Oh, he's with you.
With me, sorry.
Yes, MSS General prays for and is allowed for the 2 weeks time to file an affidavit on the question maintainability stuff. Next para MSS Tonkantree on behalf of the respondents also prays as well for that time to file affidavits according to this matter up to 3 weeks. Yes.
42.
May it please your Lordship. Your Lordship, I'm praying for further time to file my affidavit, your Lordship.
You ended appearance last time?
Yes, your Lordship.
No difficulty. Yes, MS EP pays for counsel for 1 and 2 pays for the further 3 weeks time to file affidavit. Just thereafter and so on. So.
Hello, your Lordship.
43.
I have received the instruction, Lordship. I like to file my own affidavit, Lordship. I have received this. I have received the instruction, Lordship. I'll file my own affidavit, Lordship.
You are appearing for whom?
District Council.
Who, this is council?
Yes, Lordship.
All have been served?
Lordship, that notice has not been issued to other respondent, Lordship.
As yet?
Yes, Lordship.
We'll issue the notice.
No need right now.
Okay.
I think the most important is only for the last order. Yeah, Mr. S.C. Sheikh submits that instruction be received. He prays allowed 2 weeks time to file an affidavit. This thereafter also. Don't issue note, not now. We don't issue note by response right now.
44.
Yeah, mention the whole matter. I don't do it now.
Government needs to file the affidavit.
Yes, what instructions do you have?
Your Lordship, we're awaiting instructions in the matter.
What's the matter about?
This is regarding the regularization and payment of pension, Your Lordship, of the deceased employee.
MS said, 1 to 3, pray for the 2 weeks time to file affidavit.
Obliged, Your Lordship.
45.
Please, Lordship. Lordship, steps has been taken on behalf of respondents 3, 4, and 5.
Who's appearing for 3, 4, and 5?
Lordship.
No one's appeared yet.
Lordship, through the website, it showed that respondent 3, the item had been
3 has
delivered.
been received, but not 4 and 5.
Yes, Lordship. Your Lordship, here it states that upon delivery.
No, 3 has been received. Has received, not 4 and 5.
Yes, Lordship. It states
Yes,
that
Mr.
the
Guru,
item
affidavit?
has been refused, Your Lordship, for 4. It was delivered, but then it was.
Mr. R. Gurung Lerji for 1 and 2. So Mr. affidavit will be filed within 2 weeks. Please for around 2 weeks for the time to file affidavit. So next, officer indicates that ED card. Officer indicates that the respondent number 3 has since received notice, but none appears on the behalf. However, so service of notice on respondents 4 and 5 is yet to be completed. This is matters after 3 weeks for affidavits and for service report on 4 and 5. You can obtain status in the meanwhile also.
Hearing. Item 46.
Humble prayer. No time.
if this matter is taken up after the vacation.
Yes. Urgency there, no?
There is a last time I was asked to produce rules, some rules.
Rule I have it,
some
my lord,
rules.
but
then start.
But my case was, I already argued. If they can regularize me in the post of the driver and promotion thereafter, the fixation of pay only, that is the case.
Well, that
make any notes in there. If I've already heard, there should be one.
Yes, it was already heard.
Scribbling.
Court was about to pass a judgment, but at the same time, the court found if there is any rule,
that is not the
whether
case.
it can be rule can be relaxed.
The matter was heard in several occasions, my lord.
But
then it was
last time
never
it was
completed, my lord. The hearing is not concluded or completed, my lord.
He's a poultry attendant.
Yes, that is the thing.
Not my fault. It's the fault of the government. Government said, yes, it is our mistake only. In the entire affidavit, they said is our mistake and due to oversight. But the question is that he was appointed as a poultry attendant in 1981. Immediately in 1985, he was appointed as a officiating drivers.
Officiating, my lord. My lord,
Drivers. Then after he was given a promotion to 2015.
But he is still under officiating, my lord.
Only after the retirement. Then when the matter was sent to the finance department, they said he was not regularized. We cannot do the fixation
of pay will affect, my lord, because as entry point, my lord, there is no way a poultry attendant can get an entry into the post of the driver, my lord. And my lord, my learned
look after chickens, can't drive vehicle.
But they utilized me for driving, lordship, for so many years till my retirement.
The fact that his appointment was on the officiating basis.
But you used me
only
throughout my life.
The solution, my lord, is that he has to be reverted back, and otherwise, my lord, his scale of pay, it will be difficult to regularize his scale of pay, my lord.
You're getting pension till now?
No, pension too, they are getting, they said they are giving as per the poultry attendance scale of pay. But no, we are just seeking that I should get the scale pay as per the driver's, senior driver.
My lord, there is no point of entry from poultry attendant to straight to driver. That cannot happen.
So when you're serving as a driver, you're being paid driver scale.
Driver scale.
How was the difference between poultry attendant and driver?
Driver is, I think, is a grade 4, and poultry poultry attendant grade 4. Driver is a
driver, to my knowledge, my lord, is grade 3 post.
Grade 3 post.
Grade 3 post.
Grade 3 post, yes.
Entry level itself is different, my lord. You have to enter straight away as a driver.
But not my fault, lord. This is not my fault.
No, but
this,
nevertheless, my lord, this is still an officiating appointment, my lord. It is not that he was even assuming, my lord, that he was given that post.
What rules you have?
My lord, the ministerial service rules, earlier draft rules was being followed, my lord. And then subsequently in the year 2017, my lord, the
grade 4
ministerial service rules came into existence, my lord. This was in the year 2017.
Grade 3.
But how did the department promotion committee sat and considered his promotion and promoted him?
My lord, that should not have been the case.
No, but is it dean?
Who will pay for that?
That should not have been the case.
Strange case.
Some hearing will be required, my lord.
What hearing?
No, required.
You won't allow the court to dispose the matter also on the prayer of Mr. Varasaji. This is a matter to puja vacations. Don't take any further adjournments.
I'll try to get some.
What will you get?
Some Supreme Court judgment.
Some magic?
No, that's some Supreme Court judgment.
Then
how will I say? Well, this is that magic committee matter. Well, as a matter of fact, your lordships, those papers had fallen, had somehow appeared in your lordship's file the other day after the matter was heard. Your lordships were kind enough to give us a copy. Well, this shows.
Those?
I'm sorry, Malaj.
What papers were those?
Malaj, this shows that the government has actually approved the interview board, which is to conduct the interview. And who's the interview board, your lordships, is very important.
Now, who gave these papers? Where's the government? You gave these papers?
No.
Then where? How did it come up? How did it appear in the file?
We did not.
How can the submission be accepted, Mr. Ibrahim? How did this paper come?
This is the first time we are hearing that this has come. It is never in my record. It is not part of.
My lord, if I may submit, my lord, what I am submitting, my lord, the case will die natural death on 31st October, my lord.
Yeah, then
we are on 17th, 18th, in fact, today.
We'll make it die unnatural death today.
My lord, in my humble submission, a bypass will not be necessary at this stage, my lord.
Yes?
Let him die natural death, my lord.
No need to hear it. Only that whatever
because there is an interim stay.
My lord, the only difficulty, my lord, as I pointed out in my miscase, my lord, the director has given a categorical finding, my lord, that this managing committee was never properly constituted, my lord. This is an absolutely lame and duck managing committee, my lord. At the fag end of last 13 days, my lord, they want to make an appointment, my lord.
Well, let's kindly see who's the interview board.
To the next managing committee, my lord, to make the appointments, my lord.
Your Lordships may kindly see who's the interview board that will settle this problem.
Where is that?
Resolution 2, my lords, SMC meeting number 18, resolution 2, down below. Your Lordships may kindly see.
What document is that?
These are those.
My lord, these documents are.
That is what. Where does documents come from?
I don't know.
Who produced them?
We have never produced them. This was never part of that.
Then where did they come from? How did it land up in the court file?
Earlier, Mr. Qureshi was
Oh yes, once I produced.
Then you are the culprit.
No, at the time of hearing.
These papers were given by you?
Yes. At the time there was a hearing between us. So
you didn't appear before Mr. Paul, you're not here in the case.
No, I was not the counsel.
That is the reason, yes.
I was there.
Where did you get the papers from?
Through the WhatsApp, I got the paper and then I produced before the court. WhatsApp. Court said to me immediately, actually take the instruction from the client. I took the instruction then.
Well, let's your Lordships will kindly see that it is chaired by the DCO. It is chaired by the DCO, my lords. The subject experts of arts and subject expert of science will again be two people who will be nominated by the government. The principal of the school is there, my lords, and there are two members of the SMC. So otherwise, whether it's this SMC, that SMC really doesn't make too much of a difference.
Now Mr. Qureshi gives papers. Oh.
Because I was opposing the.
So we'll have hearing to WhatsApp only next time.
Court said to take instruction, then I took instruction. I produced opposing the stay order.
At the initial stage.
Yes.
This letter is dated.
Well, it's 6th of September 2023.
Yes.
And it has been approved on the 11th of September 2023.
Yes, it is submitted at the bar that the term of the managing committee of Bhatbari, BHAIT, BARI Higher Secondary School, West Garo Hills, is to expire on 31st October 2023. Where thereafter a new managing committee is to be constituted. Stop. While this matter was pending hearing before this court, Mrs. application was filed, correct?
My lord, 197.
This application was filed by the writ petitioner. By the writ petitioner, can you say? Modification.
Take the way. This is our application. Where is the main application?
While this matter is pending hearing of the court, this application is filed by
Seeking interim orders for stay of any new recruitment to the post of assistant teacher in terms of an advertisement dated 4/9/2023. Stop. This court, in consideration thereof, by order dated 15/9/2023, had directed that no further action should be taken pursuant to the said advertisement. It appears that when the matter was conducted by Mr. M.F. Qureshi on behalf of respondent number, Mr. Paul.
Well, let's respond number 5 and 7 minutes.
On 5 and 7, on instruction, certain documents had been produced, wherein request by the school management committee for approval of the interview board which had been constituted. Where's the approval?
Well, it's on top, on that same letter, 6 September, on the right hand side, your lordships will see SO put up approval 11/9/2023.
Where it is? 6 September. Oh, yes.
It's written in hand, Malaj. This was the letter put up for approval, Malaj.
It's only put up for approval, it's not approved.
Yes.
Is it put up for
approval?
Is it approval?
It's not approved, yes.
I think the state will be in a better position to.
Never, this record was never with us. We never processed the documents of us.
These are your documents, sir. These are your documents.
It's becoming stranger and stranger, the case. I thought it's approved, but it's not approved.
Is it?
No, no.
This type of the matter was
The managing committee report.
also on behalf of respondents 5 and 7 on instruction certain documents has been produced.
Had been produced, wherein in a letter dated 6 September 2023, the constitution of the interview board had been put up for approval. Stop. Approval. For approval stamp. Change, Mr. Paul, it becomes difficult then.
Malaj, it's the issue is, Malaj, if it is put up for approval, then it's one thing. Malaj, put up approval, I don't know what it would mean again.
It should be put up approved.
Put up approved. I don't know whether this approval or approved.
Put up will be signature will be somebody else, my lord, and approval signature there will be another signature then.
No, SO, I don't know, Malaj, what SO would stand for.
Section officer something.
Then, I'm sorry, Mr. Paul.
May I pray, Malaj, let the state place before your lordships what is the position of this letter? Because this is otherwise dated the 6th of September.
Yes, Tom, no?
Can you just point out now what is the point? No, this is your letter.
For approval, stop. Stop next paragraph. This court, on inquiry from the this court is not satisfied with the answers given by the parties, especially the state respondents, who seem to be totally ignorant about the said letter. You obtain by tomorrow. Accordingly, Mr. H. Abraham directed to obtain instructions by tomorrow. Tomorrow is 19th October, and a matter be listed on 20th as regard to the fate of the approval.
This thing it has to come from West Garo Hills also.
Doesn't matter if Mr. Qureshi get by WhatsApp, you can't get by WhatsApp. Do it now only. Yeah, as if West Garo is in Africa somewhere. That should not be the attitude. Yes, you get it by today. Just ask whether it's approved. If it's approved, then let the interview go on.
Right. We'll also seek instructions in the meantime. What is the status?
Item 50.
I thought it was approved. It was approved. You would have got the order.
It is approved.
Yes, sir.
I saw that put up.
May I please your lordship? I'm appearing on behalf of Sri Ellingdor.
See?
Sri Ellingdor.
Where's Mr. Ellingdor?
His in-law vehicle was involved in accident, so he's at police
Whose
station.
vehicle?
His in-law, brother-in-law.
His in-law's vehicle is involved in accident. Mr. Ellingdor can't come.
Yeah, because
I like his excuses. Who is going for the petitioner?
but the other side has already informed them.
You already informed them?
Yeah, beyond.
Yes, on the prayer of the respondents. Should I record that his in-law's car had an accident so he couldn't come to court?
No, due to personal.
Yes, due to
Personal
possibility of the counsel of the respondent list as a matter of the puja applications. What's your name?
Bless me.
This is the first time you appeared?
First time is.
Very good.
51.
Much obliged.
May it please your lordship. Lordship, this is the case for school matter, your lordship. And here the petitioner, Srimati Pasta Kardishev, says a teacher.
Well, last time your junior undertook to argue the matter.
Yes,
In
but
case of absent of my.
In case of absence, okay. Yes.
at that time I was out of station, your lordship.
Okay, yes. What's the matter about?
Matter here, your lordship, the petitioner was appointed as an assistant teacher at Rangdikhu Upper Primary School by appointment dated 8/2/2010, your lordship. And since 2010, she was working as an assistant teacher in the school. But problem started in 2017 in the month of May. Out of sudden, her salary was stopped, though she was teaching there in school, stating that she is not a sanctioned teacher, though she was the second teacher in that school, your lordship. And she has been appointed prior to all other teachers, your lordship, here in this school. Then thereafter, your lordship, she has placed her grievances to the authority like managing committee and the secretary of the school. And thereafter, in 2018, one meeting was held and it was decided that all the sanctioned salary will be divided among all the teachers equally. Thereafter, your lordship, she started getting salary on that unique method by sharing the sanctioned salary among the teachers, your lordship. But again, in the month of April 2020, your lordship, again her salary was stopped, stating that she is not a sanctioned teacher and she will not get any salary from there, though she was teaching. And at that time, it was pandemic were there, and she is having 5 small children, and there were no other source of income. She had a very tough time, hard time, your lordship, to survive at that time. Then thereafter again she approached to the managing committee, and thereafter she approached in 2019 to the SSA mission also.
Okay, where's the appointment letter?
Appointment letter is there on page number 19, Annexure 1, your lordship. Page 19, Annexure 1.
8/2010, you appointed as, where does it say? I so-and-so.
RCUP
teacher. As a teacher. Okay, then?
Then and thereafter other teachers also were appointed, your lordship, after her. That is there in Annexure 2, page 21, your lordship. Yes. They have also other teacher was appointed after her, 23rd 3/2010. Yes. Thereafter third teacher were appointed. Yes. On again 3rd March 2010. So all the teachers, they came after her, your lordship. And the fourth teacher was introduced off late in June 2010, Annexure 4, your lordship, page number 25.
Have you made them party?
Your Lordship? No, I have not made party, Your Lordship. I have made only party to the managing committee and school because I have the grievances there.
Yes. She Dalin Linkhoi?
Yes, Your Lordship.
Okay.
And it's stated that she had joined school on 14/6/2010, Your Lordship. So
you are untrained teacher?
Yes, Your Lordship.
Okay.
All are
Now,
untrained.
qualification 10+2. Only one is BA, others is 10+2. Okay.
All the 10+2.
Also situated. Then what happened after that?
So after that, Your Lordship, me in the register everywhere I was the second teacher in the school. After the principal, I was the second teacher in the school, Your Lordship. But later on, Your Lordship, that attendance sheet or salary sheet and all everything was manipulated by putting white ink. And my name was in...
I mean, you didn't attend school?
No, I was attending. Till now, I am teaching, Your Lordship. Till now...
Any complaint against you?
No, nothing, Your Lordship. No complaint, nothing is there.
Which school is this?
It's Rangdikhu Upper Primary School, Your Lordship, situated in Makrawat, Southwest Khasi Hills. It's run by...
We are SSA school.
SSA school, Your Lordship, run by...
So the other three teachers are getting the sanctioned teachers?
They are getting...
Yeah, and you've been shunted out?
Yes, Your Lordship. Earlier, actually, my name was there as a sanctioned teacher. But my name has been removed and the fourth teacher was introduced after me of late and my name has been replaced.
What petition did you file? I've seen this one letter, Annexure 8.
Which, Your Lordship?
Where did they move now? Come to page 32. What is this? Who's the opinion managing committee?
My lord, I am appearing for the managing committee, my lord.
Oh, very good.
My lord, kindly look at the prayer, my lord. At the prayer.
Look at the prayer. Now, if she's upon before them, then how? Why did you, show only 3 names and kept out her name?
My lord, it's not like this. What my friend has projected, my lord. The first thing is that the salary which they say I've not paid, that has been paid to her. So that prayer has become infructuous. Now coming to the second...
No, Your Lordship. Again, I am not going. Later, after filing the writ petition, Your Lordship, you have got the arrears of the salary. And time to time, I got in between also, Your Lordship. But again, from last February 2023, I am not getting salary, Your Lordship. My name was there. Even, Your Lordship, I have asked to... Your Lordship, I have asked to maintain my own attendance register that I am appearing. I am not being allowed to sign in that the same attendance register.
Why? Why did it? The thing is that, see, one thing, okay, Mr. You will understand the basics. Now, it's an SCA school. There are 3 sanctioned teachers, correct?
Yes, Your Lordship.
And so, in the register, reflecting 3 teachers.
Yes, Your Lordship.
And so, because government paid 3 teachers.
Yes, Your Lordship.
Now, what management does is sometimes they take all the pay and share it among 4 teachers.
Yes, Your Lordship.
Now, your case is that you were the first teacher has been appointed.
Yes, Your Lordship.
Now, there are 2 other untrained teachers and 1 trained teacher. Correct?
Yes. Yes.
So, all along you were happily working and then your salary is being shared.
Yes, Your Lordship.
So, suddenly one fine day, although you're the senior most teacher among them, you were kicked out.
Yes, Your Lordship.
Not paid.
That's it. Not kicked out, Your Lordship. I was teaching, but I was not.
Been kicked out from the list.
Yes, Your Lordship.
In fact, the last one should have been kept out from the list.
Yes, Your Lordship.
Yes. Yes, Mr. Yubin.
My lord, it is not like that, my lord. My lord, this school was upgraded to the upper primary school, my lord, only on 23rd of February 2010, my lord. So prior to that, we were at LP school. In no way she can claim herself to be the upper primary school teacher. So the very fact that the appointment letter that was produced by my friend, that is also under doubtful, which we have raised. But besides that, my lord, we will not go into that because we also have some leniency for her. We do not want to allege her forging of document as such. But the thing is that when our school was upgraded to upper primary school, so only 3 posts were sanctioned, my lord. Therefore, we had to conduct the interview. And there is on record that this particular lady has also put up an applications, my lord, applications for appointment to the upper primary school. If what she says today that she was already in an appointed prior, that cannot be, because otherwise then why would she file in her applications,
Now,
my lord?
has she given that representation? She suppressed it. Have you given that?
They suppressed that, my lord. And therefore now, my lord, there was after the result of this interview was that three candidates scored more marks than her. So therefore, we have appointed on the three posters there. We have appointed three candidates who scored more than her. So now the fourth teacher, she's in the fourth position. Therefore, we have rightly not appointed her, my lord, So now, my lord, they cannot assert, because first of all, once you fail in an interview, where is your right to seek for a mandamus, directing, in spite of failing, directing the court to direct the managing committee to appoint her as a teacher? There is nothing. First of all, she has to ascertain her legal rights. In spite of failing in the interview, she can still be appointed as a teacher. So that is the point, my lord, here. So therefore, they have to cross that bar first, my lord. As far as the first prayer is concerned, the salary we have already paid. They have admitted also we have paid. After that, what they're saying that we are still teaching, that is wrong, because she's not teaching anymore there. Because initially we try to pay her, try to help her out with our own fund, the school's fund. But after COVID, we are a small school run by a parish. We don't have fund. Therefore, we've asked her to stop. She's not coming. Therefore, the allegation was she's saying that she has been denied in signing the register sheet and all these things. These are my humble submissions, a very wrong statement that we given at bar, my lord. Unfortunately, we should not have come at all, because this is a very incorrect statement that is given. First of all, the appointment.
Yes. You've muted yourself.
My lord.
Yes.
So what I was saying is that the appointment itself, we're not very much pressing, because otherwise then there has to be an inquiry.
Have you filed the jointer affidavit?
Yes, Your Lordship.
Have you filed the jointer?
Yes, Your Lordship, I have filed. I will come there also. I am coming there also, Your Lordship.
You filed the jointer affidavit?
Yes, Your Lordship.
Of the management committee?
Yes. I have filed a rejoinder affidavit, Your Lordship. Your Lordship, the submission made by the respondent, Your Lordship, right now she is in a school, Your Lordship.
No, wait,
still she is teaching in school. Your Lordship, this matter was
on affidavit. What have you sent affidavit? How you replied to that UP's the upper primary school issue in the affidavit rejoinder?
In para number 13, Your Lordship, in rejoinder. Para number 13, Your Lordship, may
So now she alleges that she came second in the interview, Mr. Yobin.
Your Lordship, and that has been approved by the general meeting was called, Your Lordship, in this regard. And all
these kind of facts.
All the villagers, Your Lordship, all the villagers and the elders and even the church leaders were called, Your Lordship. And they have ascertained that yes, Pastor Mary, the petitioner, was the second teacher, and she has scored the second position during the interview. I have annexed, Your Lordship, that page number 21, Your Lordship.
Rejoinder.
Yes, rejoinder, page number 21, annexer 6, Your Lordship. It's a type copy, Your Lordship, is page number 23. Page number 23, Your Lordship. May I allow to read, Your Lordship?
1 second. I'm reading the original one.
Type copy is on page 23. And thereafter again,
where is the result? We said you came second.
Your Lordship, page number 30, Your Lordship, type copy, Your Lordship, of the meeting.
30?
Huh,
No,
yes,
wait,
Your
they
Lordship.
said you came second. Where?
Yes, Your Lordship. Page 25 is handwritten. Page 30 is a type copy, Your Lordship. There it's a...
What is this? General meeting Catholic Church so and so.
This is something else.
This is...
No, it's a general meeting was called, Your Lordship, with regard to the to solve this problem, Your Lordship.
No, but how can a general meeting? Where's the result? Where's the interview? When was it held? By whom?
It was held. It's written in the appointment letter, Your Lordship, that it was held on 28 January 2010.
By whom?
By the managing committee, Your Lordship.
Where's the records of that?
That I don't have, Your Lordship. That I don't have. But even, Your Lordship,
of your affidavit.
My affidavit of opposition, page 27. That is the result.
and that is manipulated one, Your Lordship.
Very good. Very simple to say that. 27 of your affidavit.
My lord, my lord. My lord has to type copy is 27, my lord. Pastor Mary, my lord, kindly look at, she came a position 4th. Second, serial number 2 is Pastor Mary Khardusau.
One second. 25A. Came second here.
No, that's kindly look at the
fourth
last
word, yes,
paragraph of the position, my lord.
Have you seen this one?
Yes, you have seen, Your Lordship. That is also manipulated, Your Lordship. Because prior to that, I have not passed in that interview, Your Lordship. Because my appointment is prior to these people. They have been appointed, Your Lordship, on 23rd March 2010. My appointment is already 8 to 2010, Your Lordship.
Since upgraded, this was held on 22nd March 2010.
Yes, my lord. Kindly look the upgradation order.
Upgradation was 3rd February 2010, Your Lordship.
Page 15 of my affidavit in opposition, my
It is
lord.
not going to get anywhere this case on this kind of materials.
And even Your Lordship, kindly see the annexure 4 of page 17, Your Lordship, my rejoinder.
So once we got upgradation from the government here, then only we require the teachers. Otherwise, upper primary school we don't. So the interview, the result of the interview, I have just shown it to my lord. She stood on the 4th. So we have 3 sanctioned posts.
No, understood. See, Mr. Datta, it's like this. Okay. Now you see, she applied herself also on 8th of March 2010 to be considered to be combined against the upper primary post. Okay. So I don't know what they did, whether they had what kind of interview they had. Then you came forth. There were 6 candidates. Okay. First is the person who was trained. Correct. So then, how do you if she was not selected? How did he continue to work? If she was number 4, if you don't see sanctioned teachers, how did she continue to teach in the school?
Yes.
How?
Yes, she continued to teach in the school
in a managing committee post.
Yes, just by helping her, because she has been, like the way she said just now, that she is very poor. She need to support her many children. Exactly, this is what she said to the father. So the father said, okay, she stood 4th position. As a 4th teacher, we will just take her. We will pay whatever we can from the school fund.
No. There's an agreement that, the other 3 teachers, they pool all the pay, sanction posts, and you split among 4 teachers.
No, we did not split the salary. We paid to her from our own pocket, from the school, from the fund. Now she started ascertaining her rights. And then we said that we have paid to her whatever remaining money that she was claiming, and we requested her, please don't come anymore. And she's not coming since February, but she keeps on coming herself.
Where's the letter saying don't come anymore?
My lord, we have asked her verbally, after paying the money, we told her verbally not to come anymore to the school.
So at first you don't dispute her initial appointment, that means. If we accepting it, that means that you don't have records of an initial appointment even in the LP section before it was updated. Right?
LP.
Okay, fine. If she was appointed first, you don't dispute that. If you continue to keep her in service, that means she was appointed managing committee. That's correct.
No, my lord, now we are because we are concerned only
Now,
with
okay, fine. The next step is after that interview, where's approval for the teachers from the government? Is there? Were they approved as sanctioned teachers?
SSA for the other three
Yes.
teachers, my lord.
Yes.
For the other three teachers, my lord, they approve. Since that is not a question of this.
No. That is the whole basis of your case. If that the schools upgrade to UP school, then there were these teachers who appointed within the period of February and March, four teachers or whatever. Then you had a selection because on being upgraded, you had to supply the names of teachers who were to get approval as sanctioned teachers. You had the selection, and then whose names did you send? Number one. Number two, did they get approval or not? Those three teachers. If they got approval and then her name is out, then she's out.
Yeah.
But then if you can't show no approval, at the same time you're keeping her in service, that's exploitation.
Instruction from that, my lord. But then here, I'll take instruction on that part, my lord, the approval part, my lord.
You get the approval. Mr. Azhar, you have instructions. Who are the approved teachers in the school? Sanctioned teachers?
Three, my lord.
Who are they, the names?
Except this customary, other three are
Is there in your affidavit approval?
The approval is not there, my lord.
Then, what are we fighting? What are you all in the case about? That's the basis of the whole thing. If you say that she didn't qualify as a sanctioned teacher, then show that. Show that we had a selection, was approved to UP school. She applied for the being accommodated to UP school. We had a selection, this selection, we sent for approval. The DSEO gives approval, 3 teachers, she's out, but we kept her as a managing committee teacher.
I will be able to obtain, my lord.
Well, why are we having this hearing at all? If like the lawyers are not clear about, where your competing rights lie.
Earlier, your lordship.
No need for earlier or later, Mr.
I beg to pray, your lordship.
Yes, after hearing at some length, certain instructions are required. Number one, who are the sanctioned teachers? Who are the approved sanctioned teachers of the school in question, whatever school it is, and when were they approved? And 3, whether the selection as said to be conducted on 22nd March 2020 or 2010 was ever communicated or approved by the concerned respondents.
I pray, your lordship, one more point, your lordship.
Yes.
That they have asked why the letter dated 23rd to 2010 for the name of the sanctioned teacher, then whose name was forwarded?
Exactly, that's what the court asking.
You will get it.
You will get from arguing a case without, because the basics is that.
Because initially, your lordship, the
yes, enough. Listen, so.
Deeply obliged.
Yes. Yes.
Well, this is that customs matter.
Road.
Yes.
It's a road matter.
Ready with the matter to you, no? Yes. Dr. Mozika, with your assistance required, I think.
Very limited role.
Why?
Limited but important role, Malaj, I would say, because the central government notification.
Yes, what was your grounds in the case? Mr. Kinta is not well.
He's here, Malaj. He's here. He's here also.
Yes.
Well, I will take your lordships to Annexure 4 at page 29. Customs Act. First, I'll take your lordships to section 7 of the Customs Act. The lordships can have section 7 of the Customs Act. We've reproduced it in the petition, right? Section 7. Can't keep the court waiting. Give it to the court. The court must.
Is there where I don't know?
Give an extra copy. Give me from the appeal.
Yes, 7B.
My lords. I'll just read it off your lordships. My lords, 7B and C would be relevant for our purposes, my lords. You've not reproduced it?
Just reading this.
Now, they provide, my lords, for the routes, and those routes alone, my lords, can be used for the purposes of export. That is the fundamental issue on which, my lords, this entire petition hinges before your lordships. Now, in exercise of powers under, my lords, section 7, if your lordships kindly have page 29 and annexure 4. Your lordships have it.
Yeah.
Well, in exercise of the powers conferred by clauses B and C of section 7 of the Customs Act 1962, the central government hereby appoints the places specified in column number 3 of the table annexed hereto as the land customs stations for the clearance of all goods or classes of goods imported or exported by land from or to the land frontiers specified in the corresponding entry in column 2 of the said table. Routes specified in the corresponding entry in column 4 of the said tables as the routes by which alone all goods or classes of goods may pass by land or inland water into or out of India to the said land frontiers. Now, my lords, I will take your lordships to page 31. Your lordships have it, well. Khasi Hills district. Down below your lordships would say Khasi Hills district.
23.
Page 31, my lords.
Serial 23.
Yes, serial number 23, Bholaganj, my lords. And your lordships at serial number F, on the right column, my lords, your lordships will see Public Works Department bridled path from Bholaganj to Companyganj. So that is the notified route under section 7C.
Okay.
So the export, if any, my lords, has to happen only and only through that particular route.
Okay.
Other than that, my lords, any kind of export is not permissible under the Customs Act. Now the issue here, my lords, starts, if I may take your lordships, my lords, to annexure 9, page 48. As the translated copy your lordships would find at page 49. Well, this is for necessary information to all exporters dealing in the trades to Bangladesh through the trade center of Majai Land Customs Station, Sora CM ship, that they ought to renew their stickers. The stickers shall be supplied by the core committee under the authorization of the CM of Sora, as per so-and-so, dated so-and-so. To obtain the stickers, the exporter shall furnish the documents and follow the directions as follows: NOC from the CM of Sora, original undertaking from the miners, residential certificate, registration of so-and-so, trading license for vehicles without vehicles of non-tribals without trading license. Stickers will be issued only to who are to renew. Stickers will be issued from so-and-so to so-and-so with effect from 1st March 2022. Vehicles without stickers will not be allowed to transport minerals to Bangladesh through Majai Land Customs Stations, CM, Sora CM ship. Now, this is the first issue, Millets.
Yes.
Now, at page 50, Millets.
Page
50, the next page, Millets.
Yes.
Now, the district council, Millets, writes a letter to the same of Sora on 14th of February 2022, my lords, they say, with reference to the subject cited above, I am directed to inform you that the Executive Committee KJDC is pleased to approve the implementation of sticker system for commercial vehicles plying within Sora Sameship. Further, the said implementation will be only for those commercial vehicles who are willing to obtain the sticker from the HEMA and should not be forced to those who are not willing to obtain stickers. The fee per sticker should be not more than 200, and in any case of any enhancement, you need to obtain the prior approval from this office. While collecting the fee, you are directed to issue a receipt and submit the report annually to this office. Now, that letter is again followed up, my lords, by another letter of the District Council at Annexure 11, page 51. Now, your lordships will kindly see. With reference to the subject cited above, I am directed to inform you that the Executive Committee of KGDC is pleased to approve the collection of fees from commercial vehicles for utilization of the road from Majai Umdud to 0 point within Sora Sameship. The said collection will only be for those commercial vehicles who are plying within the said road. Further, it should not be forced to those commercial vehicles who are not willing to ply on the said road. The fee for each vehicle truck should not be more than 200 only per trip. In that case, there is enhancement. You need to obtain prior permission from this office. You are directed to maintain the road in good condition at times without any fail. So the issue, my lords, what emanates from this letter is that there is an approval by the District Council in respect of a notified route that some collection is being made by the District Council by the same of Milliam, by the same of Sora
to
Majai Umdud
0 point.
to 0 point, my lords. 0 point would be, my lords, the land customs station.
Okay, but one thing, geographically, is Majai and Bolaganj the same place?
Majai and Bolaganj are the same place. It's the same place. Same place.
No, because going back to your schedule, right? The 23.
My lords,
you said that is the 23 at page. Or the page 23. Sorry.
Page 23, my lords.
Yeah, you said that Public Works Department went Bolaganj to Company Ganj. Company Ganj is what now?
Company Ganj is in Bangladesh side, my lords.
Okay, Bolaganj to Company Ganj. Oh yes, Company Ganj. Okay. Right, continue please.
Well, this would probably throw little light to the query which has fallen. This is a printout of a Google map, my lords. It shows the 3 points.
Yeah, I'm going to same place, this Bolaganj and whatever.
In the same, my lords.
Yes.
And, my lords, then I draw your lordship's attention to Annexure 12 at page 52. Translated copies at page 53.
Yes.
Well, with this, it is to inform to all exporters who are doing the export business to Bangladesh through the Majai Land Customs Station that the HEMA Sora Core Committee, through the authority given by the Chief of HEMA Sora, it was informed to all exporters to paste the sticker in their vehicle. The Core Committee does not force the exporter to take the sticker except those exporter where their vehicle have to ply through the road of the HEMA from Umdud to 0 point, and those vehicles without sticker will not be allowed to pass by the said road. Now the issue here, my lords, if I may now sum it up, is that once a route is notified, my lords, under the Act,
no other route can be taken.
That's one, my lords.
Yes.
And the notification very specifically points out, my lords, that it is a PWD bridle path.
Right.
Now, interestingly, my lords, the PWD has been made a party before your lordships. Now, PWD files a very interesting affidavit. I like to draw your lordship's attention to the PWD affidavit. This one? Well, this is the affidavit filed by the respondent number 3. And if I may draw your lordship's attention to paragraph 6.
1 second. By 3.
R3, well, it's one Mr. Bonniwell Rapsang. and he is the Joint Secretary to the Government of Meghalaya PWD R&B Department.
Okay. Yes. Yes, para 3.
Para 6 minutes.
Para 6, sorry.
Well, it says that with regard to the road from Majai Umdut to 0 Point Land Customs Station, the same is not in the PWD book and therefore is not maintained by the department. So also the road from Bholaganj to Companyganj is not in the PWD book and is not maintained by the department. Now the question here is, my lords, that once it is notified and it is notified as a PWD bridle path, whether, my lords, in the face of that notification, this affidavit can sustain itself is the first question that I ask myself, my lords.
Yes.
Because it seems to be a tacit understanding of the respondents, my lords, in forcing exporters to pay money to somebody else.
The book means that, it's not under the maintenance.
That's what they're saying, my lords.
Yes.
But once, my lords, the central government...
And therefore, it's not maintained by the department.
My lords.
That means they say it's not, they don't recognize the PWD road.
They say, my lords, they don't know of any PWD road there, and so therefore they do not maintain it. The question arises, my lords, that once the central government has notified a certain route and pointed it out as a PWD path, my lords, whether the state PWD can come up with a plea before your lordships and say that it is not in the PWD book.
Yes.
My humble submission would be, my lords, it cannot be done.
Yes, okay.
Because the moment, my lords, it becomes a PWD road maintained by the PWD, there is no question of anybody else, my lords, collecting any toll or any fee in respect of that particular road.
Yes,
and the very object of, my lords, my humble submission would be the very object of Section 7 of the Act and the notification issued thereto is to ensure, my lords, that the government of India has absolute and complete control over any kind of export that happens. It cannot happen. Suppose I own a land at the border, my lords. I cannot use my land for the purposes of export.
Yes.
It has to be only through a notified land customs station. And that land customs station, my lords, would essentially be under the control of the government. It would be under the aegis of the central government and the state government. So somebody, my lords, claiming...
No, but the LCS in Bholaganj exists.
It exists, my lords.
Yes.
And the route also exists.
Under control of the customs.
Under the control of the customs, and so also has the route. There's no dispute, my lords, that the LCS exists. What I'm humbly submitting before your lordships is the LCS in itself, my lords, in isolation is not the object of Section 7 of the Act. There is a route.
Okay, yes.
So that route has to be under the control of the government of India and the state government, respectively. Some private entity, my lords, cannot have control of any export through or via his land. Now, if I may, my lords, crave your lordship's indulgence to give this example. Well, it's adjacent to the land customs station, my lords. I, as an individual, would probably could be owning some land, and my lords, that my road would be, my lords, touching upon the land customs station. Would it then be permissible, my lords, for somebody to use my land to ply a truck and enter into the land customs station and cross across to Bangladesh? My humble submission would be, my lords, in the negative. A reading of Section 7C, my lords, makes it very clear. And if I may take your lordships back to Section 7C. I think the court's book is here, my lords. Well, let's kindly see the routes by which alone goods or classes of goods specified in the notification may pass by land or inland water into or out of India or to and from any land customs station from or to any land frontier. So the route is specified. Route would mean the road. So once a road is notified, my lords, it is not for anybody.
The very fact use the word alone. That means that, that
it is exclusive.
Yes. Yes. Yes.
Which is why, my lords, I had sought to place that example before your lordship. Supposing my land is adjacent to the land customs station, I cannot use my land for the purposes of transporting something and bringing it to the land customs station and then sending it off to Bangladesh.
Yes.
It has to go via that particular route.
Mr. Paul, in the sense that that route exists and the Piluri authorities, they've washed their hands of the matter.
My lords, my humble submission is they cannot. Once it is notified, my lords, then it cannot be a paper notification, my lords. Then the land customs station has to be closed down.
Okay.
Because the land customs station, as I submitted, my lords, cannot stand in exclusion to the route.
Okay. Yes.
The object of the land customs station is, my lords, having the land customs station along with a route. It's like a checkpoint on a route. There is a road from point A to point B, my lords, from India to Bangladesh. And somewhere in between, my lords, there is a 0 point where you put up a land customs station.
Okay.
Correspondingly, my lords, Bangladesh surely would have a land customs station on their side.
What do the unions say about that?
I'm sorry, my lords.
What do the unions say about that?
My lords, I will take your lordships to the union affidavit.
They have a respondent number?
My lords, respondent number 1, my lords. My lords, in paragraph 4B, they admit to that fact, my lords. I'll just very quickly read 4B. That with regard to the statements and averments made in paragraph 3 of the writ petition, the deponent states that the central government, in exercise of powers conferred upon unto it under section 7 of the Customs Act, has notified the Public Works Department Bridle Path from Bholaganj to Companyganj as an export-import route under section 7(1)(c) of the Customs Act 1962, serial number so-and-so, well, it's 21/11/1994 that I've already placed before your lordships. As per the said notification dated 21/11/1994, Bholaganj is notified as the land customs station in terms of section 7(1)(b) of the Customs Act, and the Public Works Department Bridle Path from Bholaganj to Companyganj is notified as the route by which alone all all goods or class of goods may pass by land in or out of India to the said frontier, that is Bangladesh in this case. As such, it is incorrect for the petitioner to say that by notification dated so-and-so, the central government has notified the import route, which the PWD Bridle Path from so-and-so to so-and-so is notified place for clearance of imported goods reported for export in terms of section 7(1)(b) of the Act of 1962, whereas notified route is through which the imported goods, export goods are to move into or out of India or to any land customs station or from or to any land frontier in terms of section 7(1)(c) of the Customs Act. In a sense, my lords, they say that this is the only route through which it can be done. Now, last.
Now, what you said, as such, correct the petitioner to say that white notification is.
I'll just take your lordship to what I had said in paragraph 3, my lords.
Confusing what he's saying there. Last paragraph, last sentence of this.
I'll take your lordship to what was said in paragraph 3. Roman 3, my lords. The arbitrary, unjustified and illegal action on the part of the respondent core committee in issuing the impugned notice dated so-and-so, which all in all is without jurisdiction and authority, thereby directing that only export commercial vehicles with requisite sticker issued by the said respondent will be allowed to ply through the notified export road towards Bangladesh with effect from 14/3/2022, and that this direction issued by the respondent core committee is wholly unwarranted, unjustified and without authority insofar as the central government in exercise of powers conferred unto it under section 7(1)(c) of the Customs Act had by notification dated so-and-so duly notified the export route Public Works Department bridle path from Bholaganj to Companyganj as the land customs station, wherein all goods or classes of goods imported or exported by land from or to the land frontier shall take place.
Any answer that?
May clarify on this one. But in para 3.3 they are saying, very lots of seen section 7 of the Customs Act, where clause B talks about LCS, land customs stations. 7C talks about
route,
export route. Now these are two separate things. Land customs station is a particular station, and the route is the road leading to that. In para 3.3, what they are saying that the entire thing is land customs station, which is the bridle path from Bholaganj to that is not the land customs station. That is the export route. That's 7C. So that is why we would deny that. The statement in para 3.
No, maybe they didn't mean that, but the thing is that what they want to advance is that there can be one route, the notified route. And so that notified route is from Bholaganj to Companyganj, correct? And the land customs stations at Bholaganj, correct? Now the only thing, now they're saying that the state cannot shirk, the responsibility of saying that the road should not be under its maintenance, because it is as per the notification, the PUD bridle path. That's simple as that. That's the only thing. And so, if it's a PUD bridle path, that means no other authority has any right to impose any kind of restrictions on the plying of the vehicles there. That's the sum and substance.
That's the sum and substance of the.
They are trying to draw strength from the word used PWD road in the notification.
That is that. See, we'll come to that also. I want to come to that because that now we come to we have it goes to another. What is bridle path? Bridle path is a horse. Actually, the horses used to go all over Hasil before they have bridle paths, where horses ride. So, I mean, this definition given in the Act also, fine, it means road, but how can and if it's a PUD bridle path, then it's, by reading it, naturally it means that it should be under the control of PUD, right?
And bridle path, from what has fallen from your lordships, would historically be under the control of the PWD.
Historically means PUD bridle path is for riding.
But here what happens, customs only notifies a route, that this is only route through export or import can happen. Now we do not declare the ownership, who is the owner. That can be state PWD, that can be a national highway, that can be a district council road, that can be a village road. So to say that only because central government is notified, it becomes a government road.
No, but the central government has notified a PWD road. And there is a distinction.
Even mentioning of PWD, because the Customs Department by issuing notification is not issuing a declarative decree that.
No question. It is by common knowledge. You understand? Common knowledge says that that is all of the PUD road. Yeah, that's what. For many years. So that's when notification comes. What is this, a PUD road?
But whether that can only from on that strength can
no, that's what the school have to examine now. Whether how justified is the state respondents in saying that might be a PUD bridle path. That's just a nomenclature given 100 years ago. We don't control the road anymore. But that is the thing. And how can the court sitting here, give sort of a declaration that that is.
So, my lords, in that event, the central government is basically trying to say, my lords, they just issuing paper notifications.
For them, what they're trying to say is that they're only interested in sitting the LCS and collecting the custom duties. They don't care where it comes from.
But then you'll have to do it. Till such time it is not done, my lords, the inference would be PWD road.
The petitioners is this. Now, if it is on a road maintained by a traditional head or by a local authority, then they have the right to impose some restrictions because if they keep in the road maintenance. Now, as what I think earlier on there are some earlier cases where it has been stated that the CM of Sora is maintaining this road.
That's the case.
That's the case. And that this sticker fee is taken, or whatever charge is taken, goes to the maintenance of the road. And now from PUD, Mr. Shilai has said that we don't maintain the road. And who maintains the road?
It can so happen. Nowadays, national highway also there are toll gates. So suppose that this road is converted to national highway, there will be a toll gate.
No, but that toll will be collected by the national highways. It cannot be collected by Mr. XYZ saying that national highway has gone over my land, so I will.
Orders will leave it open-ended.
Well, that would not put an end to the controversy.
Then there'll be directions. They have to take a call.
I'm sorry, Milind.
We'll have to take a call on it. See, it has to be a quietus to the entire thing. It can't be left open-ended orders from the court, but then that will call for further action from the respondents.
May it please your Lordship. Lordship, kindly come to page 51 of the writ petition.
Okay.
This story has been sought specifically by this honorable court from the state, your Lordship.
Page 51.
51, yes. Annexure 11. His Lordship is pleased to see that annexure.
Page 51.
Yes, Your Lordship. This is the annexure which is being challenged by the petitioner. Lordship, it says like this, with reference to the subject cited above, I am directed to inform you that the Executive Committee Council Autonomous District Council is pleased to approve the collection of fees from commercial vehicle for utilization of the road from Majai Undur to 0.0.
What 0 point?
Yes.
0 point is where the land custom station is.
From the road, from the thing, from the map given, Umdut is here. Starts from there, it goes to Bolaganj Bazaar, then it comes straight to Bolaganj LCS.
That is the Majai LCS. But 0 point is where the border of India ends and the border of Bangladesh also ends.
Your Lordship, to 0 point, we have filed the affidavit. You say that no, this is not the road maintained by us.
Yes, you have anything to say?
Yes, Your Lordship. In my affidavit, I have already replied on that, my Lord. And even in the national. In my affidavit.
Respondent number?
5, 6 and 7. I am responding now. I am replying on 7.
6 and 7.
Yes.
No? 6 separate affidavit, 7 a separate affidavit.
Yes. So on respondent number 6, affidavit, my.
Yes.
Yes, in this annexure 2.
Page?
Annexure 2, page. I'll just see the page. Let's see. Yes. Page 21.
Of the affidavit?
Yes, ma'am.
No.
Maybe page 26.
26. Yes.
Yes. Important announcement? No.
Translated copy.
Important announcement?
Yeah. And type copy is annexure 2, page 28.
Page 28 is a photo. Annexure 2 is not type copy. Annexure 2 is a certificate of registration of societies.
Yeah. Just second here. Just second. Freeman. Yeah, I'm referring to the table number, serial number.
No. What you are referring to by number 6?
Yes, for the respondent number 6 for the chief, he must order.
The first affidavit.
Yes, in his affidavit only.
Annexure. The first annexure, page 25, is Jankitip Baran
announcement. Yeah, I think another annexure. Let's just. There's a lot of. Oh yes, here, my lord. Sorry. This is a type copy only. Annexure 9, page 44, my lord. On next is page 45, annexure 10A. Yes. This is the map. Since he is bringing a map of the Google, so I'm showing the map from the custom. Page 45.
Yes.
Annexure 10A.
Yes. What map is this?
Yes, in this map, my lord, the National Building Construction Corporation, when they acquired the land for the border fencing, my lord. Yes, for the border fencing, when they acquired, they have given, in page 52, they have given and identified the land between pillar number 1245 to 1249. In which petitioner has stated that the pillar number 124, 1248 belongs to the custom, but the National Building Construction Corporation (NBCC) has identified that in annexure 10F, page 52. 10F.
Can't read 10F. Anyway.
Page 52. He has identified that the pillar number 1245 to pillar number 1249, including pillar 1248 mentioned by the petitioner, belong to the same of Himasora, annexure 10F, page 52.
How, where does it belong? See 11,008
In the
letter.
acquisition table, you might, in the acquisition table.
We're getting nowhere. Yes. Where's the question table?
Yeah, I'll just, the table.
We're sinking
Page
deeper and
59.
deeper into disputed facts.
Yes, page 59, annexure 10H.
We're going deeper and deeper into disputed facts.
Yes. This is from long time, from 1987 something. You'll just see this annexure, my lord, page 59. This is the table. And you can see from this side, when he signed, when he acquired the land, the person, the landowner, the table
I
landowner.
can see the signature of CM Ulfara.
Yes,
Okay.
same of sort. Because of that, your lordship, that question of being a part of the route, being a road, identified by the petitioner here, belongs to Himasora from
now
time
the
immemorial.
point is, coming back to the core issue, let us digress, is that his only thing is that if a road notified under the Customs Act, which is pursuant to section 7B and C, which identifies the road as a pillory bridle path, there's no more room for any doubt that it should be a pillory road. And if it's a pillory road, that means that local authority will have no jurisdiction to put in restrictions. That's all.
Union has all the answer to that. That section 7 Custom Act is out of this jurisdiction only. So I don't have any say on
Yes,
that.
Mr. Kinta.
Union is saying that.
We'll need your assistance.
I think there is a thing that is being tried.
Court can sidestep this issue by going on the pleadings of the petition. But it's interesting point. Yes.
I have a take, Your Honor. The communication between the district council and the same, I think we can, is already diluted. The issue before this honorable court is that particular area that my colleague has mentioned is a road. I beg to disagree with that. When we talk about a route means a way, a path from one place to another place, from A to B. But when we talk about a bridle path is a horse track path, not a road. Let's go into the dictionary meaning of bridle path. Means a horse track. It's not exactly a road. So Your Honor, when it was notified, what was notified is from point A to point B, that is a bridle path. But the road in question is a private road of the same of Sora. It's a private property, not acquired by the state or the union.
Not built on a bridle path.
It's a bridle path. Now we go again into page 31. It says about BWD bridle path, Bolaganj to Companyganj. Now when we talk about bridle path, it doesn't say about a road. The route in question means a bridle path, not exactly a road, Your Honor.
Now we're splitting hairs.
That is, what they are trying to say. The road.
Okay, if that is a submission, does a bridle path exist today? Like that Moplang and
It exists.
It exists. Bridle path exists.
It still exists from Moplang to Lat Moplang.
Fine, that bridle path exists. But does this bridle path exist now? This one from Umdut to, this one from Companyganj, Balaganj to Companyganj. Does it exist? It exists.
Of course.
It's off-road.
They are off-road.
Does it exist?
Yes.
My lords, my only take to the submission of what my learned senior is arguing is that all export from Majai has to stop immediately. If this submission of the district council and the same of Sora and the Union of India is to be accepted, my lords, all export trade has to be stopped now, because any export from that point, my lords, is illegal.
Let me.
Because, my lords, if what they're trying to say that there was a bridle path, now there is a road. And the export now happens through the road and not through the bridle path.
It's not a notified road.
Let me extend my submission. The submission of my colleague.
Extend.
Let me. We talk about what my colleague is saying. that may be okay insofar the rest of the country is concerned, where they are sharing border, international border. But when you come to Meghalaya, when there is no revenue records, when the land belongs to the private individuals, not to the state, then that idea of saying a road being a notified road, etc., will not hold water. Rail part cannot be compared with any other thing.
There are private entities road also now in existence, my lord. There is a Nongri Gurgaon Export Road, which is manned by a private. He's saying that there's no
that has to be legal. It has to be curbed.
And they charge 500 per.
Well, it has to. If this statement is being made at the bar, your lordships will take note of it, and state and central government will be directed to immediately stop it.
In Maulong area, there is a Belfulin. That is also a land custom. It doesn't pass through any notified road. It is through private roads.
It has to be. No, it has to be. I don't think, my lords, there can be any exception to section 7C.
Yes.
The Custom Act is not appearing. And the division bench, my lord, has give a prima facie observation of my respondent number 6 that we are. Yeah, in the division
It's the same
bench.
matter, my lords. We carried the matter on appeal.
Writ appeal.
Matter was sent back over here for consideration and disposal. The
same case.
I will just
Same
read,
matter.
my lord, in this.
It was disposed of by this court, Iran? No.
Does not
Against an
interfere-
interim
does
order,
not
my lords,
interfere
made
also in the
So
order.
that was only, those findings are only with regard to the interim, but the division
I'll just
bench
read-
does not
I'll just
express
read
any
the writ
merits,
appeal.
anything on the merits of the matter. Show me the division bench.
I'll just
What
read-
does it say?
I'll just read what the division bench has observed in para 7 of the order dated.
Now one thing, okay, if you
26.
start stickers out, there's no more stickers anymore.
No more. Even the core committee is no more the man by
We didn't allow the core
NGO.
committee
Now we
anymore.
have only.
This court had
Yeah,
outlawed
we
that
have
core
only scrapped
committee.
that all.
And the other withdrawn. Now the only thing is that now, are you levying any kind of fee on the amusement road? We have to
only
levy.
in the toll. Only in
That
the
has to be
toll.
under toll, yes. Okay.
Under private roads, you can do that.
Yes.
According to us.
So that land, that road in question.
And even the custom office is now still under a running agreement with us. Only the lease is going on from 1987 when they asked for the permission
that's
from the
immaterial.
HIMA.
Anyway, yes,
It's
what are you
still
trying
there.
to say? Just now, report to division bench order.
Yes, I'll just read. Para number 6. Para 6. There is no doubt. There is no doubt that the issues query raised in the pending writ petition pertains to the very authority of the Himasaura's aimship to levy the toll, particularly when the route, ROUTE route, has been identified for use by vehicles for export and import purposes and also indicated as a PWD road in relevant notification. There is no doubt that this aspect will receive adequate attention. However, in view of the aforesaid judgment and its prima facie appear that the Himasaura steamship may have due authority to levy the toll, the interim order imputed herein is not interfered with.
It's clarified again in para 9, my lords.
And again,
para 9
I'll
also.
just.
Please read para 9.
Read para 9.
Yes. It is made clear that none of the observation herein, including the reference, because the division bench
Shall
has
affect
referred the Meghalaya
that's
Trucks
the
For
Association.
adjudicating, because
Yeah.
division bench had left it open for your lordships to adjudicate the issue.
Yes.
That judgment, my
preclude
lords,
the
will
trial
not
court
come in
from
the
the
way
adjudication.
of this particular issue
But
that's
the
there.
Meghalaya Truck
If they want to get into it, my
Association
lords, I can respond to
still
that.
there. And it's not disputed that we are one of the.
Well, it's my only submission before your
Public
lordships is
authority, he must-
restricted to just this one issue, my lords, that once a route is notified.
No, but the very fact, fine, Mr. Paul, but the very fact that a notification exists, no one doubts. But whether, what does the notification, imply, how the authorities who are supposed to impose the notification, they have it's totally, they say, you don't know. And then even the state says it's not our road.
No, my lords, union does not say they don't know. Union on affidavit says that is the notified route.
Notified route is, they don't know. They have not come out clear. They said that there's no declaration from us. A notification doesn't mean that it vests the power PWD. Because PWD doesn't mean that once we notify, that is incumbent upon PWD to maintain it.
If my lords kindly permit me this,
yes,
little indulgence. The central government, my lords, passes a law. The parliament of this country, my lords, passes a law. Under that, my lords, the executive is directed to make certain rules or issue certain directions. That is done. That is not under challenge by the CM of Sora or by the district council or by the state of Meghalaya.
Correct. But
my lords, where would then your lord...
Understand, Mr. Paul. Forget about, technical law right now. We are into disputed facts. Now, whether,
My lords, in my humble submission, there is no dispute.
Of course. Now, PWD says that we don't,
My lords,
there has to be inspection conducted.
My lords, what I'm humbly submitting before your lord, what I'm humbly submitting before your lordships is, my lords, the PWD cannot say that they don't have this on their books.
That's what they've said.
My lords, they cannot.
That's what they said.
My lords, tomorrow some officer of the PWD is going. My lords, tomorrow somebody is going to come and say that.
That is why
central government might have passed a Customs Act. We are unaware of it.
That this court cannot come to a decision and say yes, because firstly, brittle path. Number two, now there's a local inspection has to be done. Whether this road,
my lords, brings me back. My lords, brings me back to that fundamental principle of law that ignorantia juris is non-excusat. So if there is a legislation, my lords, somebody cannot say that I'm not aware of that legislation.
Where's the table 23, page 23 web petition? Let's see again.
Page 31.
Page 31. Yeah.
31, my lords. And the fact of the matter remains, my lords, none of the respondents have challenged this till today.
Page 31, item 23.
Now, somebody, my learned senior on behalf of the district council has made a submission that may apply to the rest of the country but not to Meghalaya. I don't know whether constitution carves out a specific exception for Meghalaya.
All over Meghalaya, your lordship. This is the scenario.
Factually, maybe. Where is the law?
No, we are aware of that. We are aware of private operators in other areas like Borsara making their own roads and to go that, but that is acceptable. That it is just on the ground kind of arrangement because the official route is unusable. That is why. But in this case,
my lords, the official route is made unusable so that these private routes can survive.
Even this one's been made unusable now.
Why, my lords,
you mean to say that this?
My lords, why would the PWD say that we don't maintain it?
Yeah, that means it's unusable.
My lords, they are trying to make it unusable because so that these private roads can occur.
Mr. Shulai, I think I will direct your chief engineer to do a detailed inspection.
And let them produce the records before your lordships.
Because we go by the notification of the district council, your lordship, whether the road from Umdur to that 0 point.
You file a detailed affidavit. You can't just file one, 3 lines and say that it's not in our books.
And let them produce the records, my lords. Show the books for Assam time.
Same. But then if you present an answer, there has to be like a sum. A problem is given. You just write the answer. Like we don't know what are the steps you took to. Yeah, you have to have what are the logical steps, logical progression to arrive at this conclusion that it's not your road. That's why I'm saying open-ended order. Even if it disposes open-ended, and we can't dispose it also.
Because what is happening, my lords, this is leading to illegalities all across the state. Fly-by-night operators are working and the state is a mute spectator to it.
What mute spectator?
My lords, active participant. Active, your lordships have corrected me. Actively participating in it.
We are all not mute spectator.
And the new notification, my lord, in 2010, in which the union has annexed also in its affidavit, in 2010, they have mentioned in the Annexure 2 of the Affidavit of the Union of India that the custom areas of land custom station from table serial number 2 Bholaganj meaning Majai, A, 50 meter on the eastern side, 15 meter on the western side, 10 meter on the northern side, and 20 meter on the southern side from the loading starting point of Komara, because Komara this is a company, my lord, and the Komara is existing the roadway from Soabar and it ended to Himasora. And this Komara has an agreement, running agreement. We have the
Komara has in Majai only.
Yes, in Majai only.
Lords, what my learned friend is referring to is a notification under section 8.
No, forget about that.
Take down.
7 and 8 are very different.
Take down. Okay, take down. We will just try to come to some logical kind of conclusion. In the course of hearing, a pertinent question which has arisen is as to the status of the road, notified route for export,
Yes.
as it appears at annexure. Your annexure is what?
This is annexure 4.
Annexure 4.
Page annexure 4, Malas. This is the notification
which
dated
contains a notification dated
21st November
1994, wherein the route shown at serial number 23 bracket F is as follows. I'll flag it for you. Stop. Next paragraph. It is noted that the same is designated as a brittle part as a public works, as a PUD brittle path, to which the state respondents in the affidavit maintains, the affidavit have stated that the same is not in their books, and therefore
No, Your Lordship.
it's not. You said it's not in your books.
It's there specifically at paragraph 6.
We go by the order.
No. Do you clarify it? You clarify it. No. This is the order. Please listen to the order. Where in the affidavit they have said it's not in the books, and therefore it is not under the maintenance. The statement made in the affidavit. In the affidavit.
Para 6 minutes.
Yes.
Para 6, Your Lordship.
Yes.
Majai umdut to 0 point.
Yes.
As per the letter issued by the District Council to the
Where's the affidavit? One second.
This is the affidavit filed by R3 minutes.
Yes.
Can I say something?
No, wait, mister. You can see. Let's see the order first.
Designated as PWD brittle part, to which the state respondents in the affidavit have stated that
At para 6 as follows. I'll flag this also. Because they already said, so also the road from Balaganj company is not a PUD book. Okay. The para 6. Where it has been stated.
the state responding to the affidavit have stated that the same is not in their books and therefore it is not under maintenance.
This statement is contained in para 6, which is reproduced here in below. Stop. Next paragraph. As a pointed submission made is that only the route which has been notified under para 7 under section 7C of the Customs Act of 1962 will be the permitted route. The question before the court is who is the question of the court is what is the actual import route being used, export route being used by exporters, and whether it is the same brittle path that has been mentioned in the notification. Stop. The PUD authorities are also to come up instructions as to whether they exercise any form of authority over the said brittle path as it existed, as it earlier existed. Stop. When can it come? Yes, what assumption you want to
I
make?
wanted to say this, if that order were to go through, it will send a wrong meaning altogether because Public Works Department brittle path from Baloganj to Companyganj. That has to be added. From Baloganj to...
That's what is called in para 6.
Because Balaganj
Just stop
and
there.
PWD road is there.
See, one thing, just in para 6, what is in para 6? That regard route from Majai Umdut to 0 Point Land Customs Station, the same is not in the PUD book and therefore maintained by the department. Stop. So also the road from Baloganj Companyganj is not a PUD book and not maintained by the department. They made that categorical statement, Mr. Kanta.
No,
you see the affidavit.
That item 23 just now. So it should not stop only brittle path. Public Works Department.
No, we're quoting that. We're quoting the 23.
From Baloganj to...
See, we're quoting it. It'll be quoted. It's quoted. Public Works, yes. The whole, this one will be quoted. It'll be reproduced in the order. Don't worry.
Baloganj to...
Yes, the respondents are therefore to supplement their submissions, to clarify the matter, and to produce necessary records if necessary on the next date. Yes, on so and so after publication. At Limo, this one is kind of 423. Can you public works department by little part from Balagan company and just only quote F and that affidavit.
In fact, Your Lordship, the subdivisional officer or the deputy commissioner, right people to identify.
Doesn't matter. Let's see what they come up first. They're coming up.
Let them come up with the records, Melons. The records will speak for themselves.
Record is there.
Records. You'll be surprised. They'll be.
Also, only one aspect also that those areas also are close to us, like.
Yeah.
Man-made or natural?
And there's no other route now except, and if our road is closed, we will just make another mall there in that land. And no
The
more
first
road.
time we're seeing, Melons, the state is not wanting to be in control of the resources of the country. Very unfortunate.
Yes, Mr. Siddiqui.
Oblige, Your Lordship.
My lord, I was under the Sedicate Culture Department, my lord. They have framed a rule which is known as.
We'll have it after vacations, Mr. Siddiqui. It'll be quite long. Yes, sir. A request of the parties matter of Puja vacation. Yes, next. Police spoke on matter also today. Alud. Thank you. Sorry to make you wait.
Obliged, Your Lordship.